case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin, and I'm joined this morning by Justice Singh and Justice Hand. We will be hearing 6 cases this morning. We are hearing these cases by teleconference due to the ongoing pandemic. The rules for argument are the same here as they would be in person at our courthouse, which is to say 15 minutes per side and no rebuttal. The first case we will hear this morning is Commonwealth versus MONTEIRO, number 20-001. And we will hear first from Attorney DeMello.
Good morning, Your Honors. Kevin DeMello on behalf of the defendant, Mr. MONTEIRO. The defendant's case here is that the prosecutor's argument that Ms. Chung, and by implication, Mr. MONTEIRO, demonstrated consciousness of guilt was improper because it was not based on the evidence of concealment or flight, but otherwise innocent behavior. Now, a prosecutor's argument, as we know, based on the case law, must be based on facts in the record or reasonable inferences therefrom. And the case I would analogize to here is Simmons' case. In that case, the prosecutor argued that someone was in the Army, the defendant was in the Army, and because they were in the Army, they knew how to kill and they knew first aid. And the court held that those were not reasonable inferences based on the fact that the defendant was in the Army. So applying that to this case, the theory is that the argument was not based on reasonable inference because asking to stay at a friend's house like Ms. Chung did, car the next day, as Ms. Chung and Mr. MONTEIRO allegedly were, those aren't better concealment. They're otherwise innocent acts. And if you look at some of the other case law that were cited in the briefs, the Franklin case, the Horseman case, the Tony case, in all those cases, the facts are markedly different. In the Franklin case, you've got someone who committed a crime and then fled out of state. That's not happening here. They're just down the street. In the Horseman case, you've got someone who was spotted in a fight and then briskly walking away and then breaks into a run. And you don't have that here. You have 2 people who were spotted, pulling into an apartment and staying the night. In the Tony case, you have police who are searching for the defendant. They make repeated attempts to find them at home. They start speaking to the relatives to try and locate them. The prosecutor is able to argue that the defendant's avoiding the police. We don't have that kind of thing here either. There's not repeated attempts by the police to find these people. Again, this is otherwise innocent behavior. They're going to Mr. MONTEIRO's girlfriend's house. They stay the night for reasons that are explained on the record, ostensibly because they're tired, it's late, they've been smoking marijuana, they're perhaps intoxicated, and then the next day they're spotted in a different car. That alone should not give rise to a reasonable inference of consciousness of guilt.
Counsel, isn't that the nature of consciousness of guilt evidence, that it could be innocent, but you could draw an inference of consciousness of guilt?
Well, I think that's true in general, but I think then you have to look at the specifics of this particular case. And again, you look at the Simmons case, just because someone's in the Army, it might give rise to an inference that they've been trained in combat and therefore knows how to kill, but is that really a reasonable inference? And in that case, the court held that it wasn't. And the defendant's position,
in that case, you're drawing an additional you're drawing an additional fact, not simply an inference from that they were in the Army, but you're adding something that they know how to kill, that that's what comes from it. Here, the inference is simply, why was she in another car? Was it because she was trying to avoid being seen in her own car? I mean, there's no additional fact that's being introduced that wasn't in evidence.
I understand what you're trying to say, and I can only reply with the defendant's position is that, when you look at the facts here, that they're simply seen in a different car the next day, that shouldn't be enough to give rise to an inference of consciousness of guilt. I mean, it's such an innocent act, and I would also sort of bring into this the prejudice argument. Maybe in a different case, this wouldn't be as bad. But here, you've got a really close case of circumstantial evidence. You've got a very equivocal identification, and identification is really at the heart of this case. And so these arguments of consciousness of guilt really go to the heart of the case, and they make this situation a much more difficult question and a much more difficult inference to draw.
Well, when you talk,
go ahead.
when you talk about these arguments, specifically your objection now as to the closing argument had to do with that, asking the jury to draw that inference just from the car. Was there anything else?
It was Ms. Chung staying the night, asking to stay the night. That was argued first by the prosecutor, and then second, he argued that being seen in a different car the next day was consciousness of guilt. So it's page 53 on the January 14th transcript.
So with respect to both of those, you're arguing that they were not permissible. It wasn't permissible to argue consciousness of guilt as to those two points, asking to spend the night
Correct.
and being seen in a different car.
Correct.
Thank you.
And again, there's factors to consider as to whether this was unfairly prejudicial. I've touched on some of them. Some of the others, there's no mitigating instruction. And I understand there's no requirement for an instruction on consciousness of guilt, especially when one is not requested. But that is one of the factors to consider, whether or not there's a mitigating instruction as to whether or not this is a prejudicial error. And there wasn't one here that specifically addressed this issue. The other issue that I think is important is that this was done in Commonwealth's closing argument. The defendant had no notice that this was going to be argued, and had no way to respond other than, perhaps to lodge an objection. And I understand that the defendant didn't lodge an objection in this case, but given that they had no notice, that perhaps they weren't ready to respond to this kind of an argument, is perhaps an explanation why.
Is notice required?
I'm sorry?
Is notice required?
I don't believe legally notice is required, but again, just sort of analyzing the prejudice issue here, the fact that there was no notice can sort of go to the fact that the other side of this argument is, well, there was no objection, so how bad could it really have been? Well, sometimes it's hard for a defendant's counsel sitting there at the table listening to an argument for the first time to jump up and say an objection, and maybe the defendant missed it in this case. In any case, if there's no further questions on that argument, I'd like to move on to the identification issue. In this case, there was a photographic array identification. One of the witnesses, Riyadh, provided that identification. And the defendant's position is that that identification should have been suppressed because the circumstances of the array were somewhat suggestive, and the initial observations that were made by the witness were made under conditions that precluded a reliable identification.
Didn't the judge make a determination that they were not unduly suggestive, that the ID wasn't unduly suggestive?
That's correct, he did. However, if you look at the Johnson and the Carter cases, what they specifically say is, even when an identification is not unnecessarily suggestive or unduly suggestive, if there are circumstances that would give rise or are suggestive to some degree, that triggers this reliability analysis.
Are you suggesting there was anything wrong in how the array was conducted itself? It seemed to me that they sort of followed the book step by step.
I think there were a couple of issues, and those were issues that were raised by defense counsel in sort of the first part of his motion, suggesting that this was unnecessarily suggestive. I'm not sure that I disagree with the trial judge that these errors rose to the level of an unnecessarily suggestive identification, but there were issues. The original description of the perpetrator here didn't match the people that were chosen in the array. Instead, the array, the second array I'm talking about, where Mr. Montero was identified, the people who were in it were chosen because they resembled Mr. Montero.
What's the solution to that situation where you have filler photographs that are in line with the photograph of the defendant, but you have a different description. Is it supposed to be half and half of one description and the fillers matching the existing photo, or should the fillers all have to match the description that's given in advance and have the photos stand out as being markedly different? What's the solution there?
Well, I don't know. And I'm not sure, honestly, that the police did something wrong per se. What I'm suggesting is that these issues were sufficient to trigger a reliability analysis. So in this case, you've got observations that were made under conditions that were very difficult. And in a situation like that, the judge, when there are issues with the array, as there were here, the judge should look at the reliability analysis. And that gets us into, the fact that there was very poor lighting. The police had to bring in floodlights here just to do their investigation.
After the fact, when it started raining, correct?
Correct, but I mean, if you look at the judge's findings, the finding number 4, he's talking about how dark it is. So, I think it's a fair factual finding that it was dark out. I mean, this wasn't obviously before the motion, judge, but then when you look at the testimony at trial, all the witnesses are saying that it's dark out. But in any case, that's not the only factor. It's a high stress encounter. There's a fight, a gunfight. There's a short period of time to make this identification. The factual findings talk about 15 minutes, but what they say is that, it's not a face-to-face 15-minute encounter. This person, the perpetrator, is sitting in their car on a dark night for 15 minutes, and only then is there a confrontation, and that confrontation results very quickly in an altercation. So I suggest that the 15 minutes is even misleading. It's even shorter than that this witness really has.
But aren't these issues that really properly should be in front of the jury to sort of, for them to assess the reliability?
I think generally that's true, and that's the typical response to any arguments about photo array identification. Well, isn't this just cross-examination material for the jury? And again, the defendant's position would be, well, the case law tells us that the judge is supposed to look at this for suggestive circumstances and then, engage in this reliability analysis, and in his discretion should exclude an identification that is substantially more prejudicial than probative. And in this case, the defendant's position is that all of these factors and more made this substantially an unreliable and therefore substantially prejudicial identification. And, in the context of this case, you've got a very circumstantial case. The identification here isn't, this is the guy, it's this guy is similar to the shooter. And it's another factor is it's done a month later. It's a cross-racial identification. So, I mean, all of these issues make the reliability of this particular identification very questionable. And this is a case that's close, that's circumstantial, where every little piece of evidence could have swayed the jury. So I think the danger of unfair prejudice here was high, given the nature of the case. If there are no further questions, then at this point, I'd rest on my brief.
Excellent job. Very well argued. I think we understand your arguments. Thank you very much. We will hear now from Attorney Cusick.
Good morning, Your Honors. May it please the court, Tracy Cusick on behalf of the Norfolk County District Attorney's Office. Your Honors, the Commonwealth is asking this court to affirm the defendant's convictions. There was no impropriety in the prosecutor's closing argument. First of all, with respect to the motivations of Ms. Chung in staying the night, that she was charged with being accessory after the fact, and the elements of that include concealing a defendant who the police who's committed a crime. So it's actually an element of the offense which she was charged, the fact that the SUV was concealed in the parking garage. But certainly it was a fair inference to ask the juries to evaluate her motivations for staying there, where there was the defendant's girlfriend and the defendant, and there were 2 children in the apartment, ages 10 and 11, in a 2-bedroom apartment. And she stayed on the sofa for a few hours, and then there was evidence that she left in the early morning hours. But it was certainly for the jury to decide what her motivations were in terms of that action, asking to stay the night, and leaving. Again, I believe the evidence shows that she left without the SUV in the early morning hours. And being in a different car where she owned a newer SUV, she was seen in a different car the next day with the defendant and another person. But certainly those were fair inferences for the jury why she was doing that in terms of what the significance was. I'm not sure it rose to the level of a consciousness of guilt argument, but even if it did rise to consciousness of guilt, it was permissible for the prosecutor to argue that.
Do we know anything about this other car? Who owned it or anything?
The passenger in the car, Mr. Marta, was the owner of that automobile. And apparently his license had been suspended, but I'm not sure if that was in the record before the jury. That's my understanding of what the facts were regarding that car.
So you want the jury to infer from the fact that she has this white van that's now parked under the apartment building. You want them to infer from the fact that she's driving a different car the next day, that she's hiding the white van in the parking lot. It's not just parked there because that's where she stayed or whatever. She's deliberately not moving it because she doesn't want anyone to see it or her driving it. That's the inference you're asking the jury to draw, right?
Your Honor, the inference I believe that was exactly in the closing argument was that the jury consider why she's in this other car 24, well, okay, approximately.
But what is the why that you want them to come to some conclusion about that?
That she's not driving.
Doing it because her car is broken or because her friend whose license is suspended said, can you take me in my car and drop me at, so, you know, none of that. You want them to infer what exactly?
That she's not driving her car because she doesn't want police to see it.
Okay. What's the line between a reasonable inference and speculation? Why isn't that speculation? I don't know why she's driving another car. That could be the reason.
Exactly, Your Honor.
Okay, so anything that could be the reason is a reasonable inference.
In all circumstances, not in all circumstances, Your Honor, but here it's 18 hours after the shooting and she's driving another car. And she may have an innocent reason for that. She may not have an innocent reason. It may be that she doesn't want to be seen driving her SUV.
And why, and you think that there is sufficient evidence in the record to permit the jury to reach that conclusion by a preponderance of the evidence?
Yes, Your Honor.
And the evidence of it is she owns another car. She's parked it under an apartment building where she stayed, but which isn't her apartment building. And now the next day, she's seen driving another car. That's
yes, Your Honor.
All we've got. And
that's what we've got in the record, Your Honor. And yes, the jury.
It's not pure speculation why she's driving that other car. You think it's a reasonable inference?
Yes, Your Honor. I believe it is a reasonable inference. It's also relevant that the defendant is also in that car showing these two people together shortly after, 18 hours after the shooting. Is
that relevant to why does he own the white? She owns the white.
She owns the white car.
So the fact that is this guy her boyfriend?
No, she was a friend, and the woman who owned the apartment that she stayed on the sofa was the girlfriend of the defendant.
Yeah, I remember now. Okay, so this is her friend. It's her friend who she was clearly with last night. It's her friend who she slept over at someone's apartment, his girlfriend's apartment with, and now they're in a car together the next day.
Yes, Your Honor.
I'm not sure, how does adding the other person, I see that it supports a further inference that the two of them know each other or are close or, you know, might be doing something in concert or something. But does it add anything to why she's driving the other car?
No, Your Honor. It doesn't add a great deal other than she's not driving the white car, that her and the defendant were in the white SUV the night before, and now they're in a different car. Again, perhaps not a compelling inference, but certainly also an inference I suggest wouldn't be prejudicial to the defendant. No one objected to it. If this had been something they were concerned about, they could have filed some sort of a motion to preclude any argument about it. But again, at the time, neither Ms. Chung's attorney nor Mr. Monteiro's attorney objected.
No, I just want to make sure I understand you.
Yes, Your Honor. There's not a lot of information in the record about the background of of that car, the second car, and how they came to be in there. But I suggest that even if it was unsupported, which I don't believe is the case, it would certainly not rise to the level of a substantial risk of a miscarriage of justice at all, because the issue was the shooting and the concealment.
No, I get it.
Your Honors, with respect to the photo array, here a witness was shown a photo array. The police had a photograph of the defendant, and his hair was different than the way it was described by the witness at the scene. And certainly it is an interesting question. What does one do when the photograph police has a changeable characteristic? If a person's hair has changed, or if they've perhaps gained weight or lost weight, or anything that is common knowledge can be easily changed. And here the witness was instructed that some features can change, and looked at the photographs and selected the defendant as similar to the shooter. He didn't select anybody else as similar, but he selected the defendant. And I suggest the motion judge got it right when he said the photo array was conducted in accordance with protocols. And then looking at the reliability, certainly the motion judge made many findings about that although it was dark, there was a street light. This was not just a fleeting encounter. There was some interaction between these people for several minutes. And so I would suggest that there was no error or abuse of discretion in allowing the identification to come into evidence. And if there were no further questions, I would rest on my brief.
I see none. Thank you very, very much. Very helpful argument, helping us to understand your argument. We also have your brief. Thank you both. Excellent arguments for your clients on each side. So.
The case is now being recorded.
Good morning. Welcome to the Appeals Court. I'm Justice Rubin. I'm joined today by Justices Singh and Hand. We are hearing argument today by teleconference due to the ongoing pandemic. The rules are the same as they are for in-person argument in our courtroom, which is to say 15 minutes per side with no rebuttal. The next case we'll hear is number 19-1366, Commonwealth versus CONEY, and we will hear first from Attorney Appleyard.
Good morning, Your Honors. May it please the court. My name is Jennifer Appleyard, and it's my privilege to appear on behalf of TYRON CONEY. The first issue which I would like to discuss with the court today is the improper closing argument by the prosecutor. The prosecutor's theory of the case, which was presented in closing argument, is not supported by either the eyewitness testimony or the statements made by Mr. CONEY, which were introduced into evidence during a police interview. There were multiple mischaracterizations. Defense counsel objected not once, not twice, but 8 times to the impermissible argument, and only upon one occasion was a limiting instruction provided. The standard is prejudicial error. These problem statements are likely to have made a difference to the jury. The first statement, which I would like to address, is the statement on volume 6, page 93. The statement is, and the defendant says it in the video, he is the black male with Ace. When Ace says, "Here comes those expletives, let's get them." Now this statement, "Here comes those," was introduced into evidence. It was made by the neighbor who viewed the events of the evening. She testified that Ace made that statement. Mr. CONEY never made that statement in his interview. But the next statement, "Let's get them," was never introduced into evidence. This is significant because the theory of the case is joint venture theory of manslaughter. And whether or not Mr. CONEY joined in and actively participated was the ultimate issue for the jury to decide. Therefore, clearly an error occurred. when looking at the COSAC factors, there was an objection, so the matter was preserved. There was no limiting instruction provided, and this error was likely to be substantially prejudicial to Mr. Coney. The jury, when deliberating, provided not one, not two, not three, but 4 different questions asking for guidance about how they should consider things. And I would show that demonstrates the evidence that it was likely to have influenced the jury.
I understand. Can I interrupt you just for a second? I understand your point about the misstatement about what the defendant said. Am I correct in understanding that after the objection in this situation, the prosecutor corrected the argument to indicate the correct speaker that Gail said?
Later, yes, later on in the argument, she referred to it, but I wouldn't say it was necessarily a correction. Furthermore, as evidence that the prosecutor was aware that the defense counsel did not objected to the statement was when in the required finding argument, the prosecutor had made the statement again, let's get them. And during their oral arguments, defense counsel stated that was never introduced into evidence, which had been just prior to the closing arguments being given. The next statements, which I would like the court to look at, I would suggest, in light of the limited nature of our time, and the argument is similar, I would suggest that the arguments, as I've labeled them, the next 5 arguments all have the same challenge of the prosecutor mischaracterizing Mr. Coney's statements made during his interview. Specifically, she continues to repeat, the defendant admits, you get that from his own words, the defendant's statement, what the defendant said. If you look closely at the record appendix, specifically, I would say on pages 74 and 121 of my record appendix, you will see that Mr. Coney never admits to being present during the stabbing. In fact, he's adamant that he was not there. He certainly admitted that he was present to the fight. He does not deny that he engaged in punching him or he engaged in kicking with him. In fact,
does he not say that he saw a pool of blood as he released or put down the victim after having him in this whatever a sloppy chokehold is? Doesn't he say that that's when he saw a pool of blood?
he saw, yes, Your Honor, he did.
Is it a reasonable inference that the stabbing, that was a result of the stabbing?
Well, I would suggest that in regard to the prosecutor's closing argument, if you look at the facts which he admitted to, which was with his left hand, he engaged in a sloppy chokehold where Mr. Smith was wielding the knife with his right hand. And the prosecutor's statements suggest that it was during that time when Mr. Coney was holding him in that sloppy chokehold, Mr. Coney holding him with his left hand, that at that time, Mr. Smith was stabbed on the left side of his body, his upper chest, his arm, his thumb, and then his lower back, which would be, if you take the description from Mr. Coney's statement, he was dancing, trying to not be stabbed with a knife. So looking closely at those facts, which I would ask the court to do, it does not seem that the prosecutor's theory of the case is consistent with what the defendant's statements are.
Okay, but there's more than one statement that comes out of that lengthy description you've just given. And the one you were talking about is admitting that he was stabbed while he held him. Now, I understand he didn't in those words say it, but I guess maybe this is a reasonable inference question. If he says I was holding him, and then when I went to let go, there was a pool of blood, and then at some point he says maybe he stabbed himself. Why isn't it a reasonable inference that what he's telling you is, while I was holding him in this chokehold, before I let go, is when the stabbing occurred? I mean, I think that's your sister's argument, but
If you look at the other witnesses' testimony, though, the other witnesses' testimony is not consistent. The testimony that was consistent was that a group of them were together. I believe in one of the arguments by one of the witnesses stated that Mr. Coney was in front of Mr. Smith. I don't think that there were any other witnesses that testified that while Mr. Coney was holding Mr. Smith in a chokehold, that it occurred. The testimony seemed to be consistent that there was beating and kicking. Mr. Smith fell to the ground, but there was no eyewitness to the fact that he was stabbed. So
I asked you about the ace was in front of Mr. Coney, part of the closing, right? He's saying, the prosecutor, he or she is saying that the stabber was visible to Mr. Coney. I take it that's what's meant by that. And so he must have seen the stabbing take place. And this is, I suppose, part of getting to a joint venture finding. Is that how you understand the statements about Ace was in front of him?
correct. While Mr. Coney, I understand the statements that Mr. Coney was holding Mr. Smith. That was the prosecution's theory of the case.
He had him in a chokehold, whatever sloppy chokehold is. I don't know. The way I read the description, it sounded like first they're face to face. Mr. Coney with his right hand, grabs Mr. Smith's empty left hand, and then wraps it, not his own arm, I don't know, around Mr. Coney's neck. Now your left arm can't go around your neck this way, it could this way. So if he's holding this, he must now be behind Mr. Smith, right? How else can you hold someone in a chokehold?
That's what, yes, I mean, that's what
Okay,
the Commonwealth is.
And then why isn't it a reasonable inference that if indeed, this is another inference, but if indeed these stabbings took place during the chokehold, since some of them are in the front, including the left chest, that the stabber had to be in front of not just Mr. Smith, but Mr. Coney, who would be behind him, facing forward.
But the problem with this statements is that the prosecutor is stating that Mr. Coney made these statements, and Mr. Coney did not make these statements. I mean, this is the prosecution in the portions that I've objected to mischaracterized Mr. Coney's own words, and that's what the problem with the closing argument, because that's not introduced into evidence.
Instead of saying Mr. Coney has admitted X, it should have been more sort of step by step. Mr. Coney admitted, or not admitted. Mr. Coney said there was blood after he held him. That amounts to, I would suggest that amounts to an admission that he was stabbed, that Smith was stabbed while he was holding him. Mr. Coney said he had him in a sloppy chokehold and therefore was behind him, given that the stabbing took place. There's some in the back, on the side, on the back, I guess, but that some of the stab wounds are on the front of Mr. Coney. I would suggest that that amounts to an admission that he was facing Ace during the stabbing. that would have been, that's the problem, right? That's the problem you're identifying.
In this case, the defendant, which the prosecutor argues, stated and admitted things. The defendant did not testify at trial. Clearly, the defendant's words were something the jury considered, as we can see as evidenced by the questions. These were objected to statements, and they went to the heart of the case. I mean, this was a joint venture theory of manslaughter. So looking at the requirements for a reversal based upon an improper closing argument on misstatement of evidence, this case clearly falls as the type of case in which this court should reverse the manslaughter charge and order a new trial. We can look to guidance from Commonwealth versus Lagadidis and Commonwealth versus Shelley, which were both cases which were objections were preserved upon the record, and went to the heart of the case, and the court ordered that. I mean, clearly mischaracterizing statements of Mr. Coney himself is extraordinarily prejudicial and shouldn't occur. I would briefly touch upon the sufficiency argument, and I would suggest to the court in looking at this argument, if you would look at, and I'm happy to get the video transferred to the appeals court if the court would like, but Exhibit 32, which is the video showing the individuals leaving immediately following the fight, shows consistent evidence that Mr. Coney and Mr. Strong left ahead of the other individuals. There are three different views of the individuals leaving and walking up the street. However, I would suggest to the court that that information provides, it shows that the statements, although Ms. Simas provided contradictory statements, and a number of these witnesses certainly had some challenges at best, but I would say that that Exhibit 32 is important to look at when looking at whether or not what story to believe by what eyewitness, because there clearly was a lot of contradictory testimony in this matter. I see that my time is running out, but if the court has any further questions, I'm happy to answer them. Otherwise, I rest on my brief.
I see none. Thank you very much for an excellent argument, Attorney Appleyard. We will hear now from your sister, Attorney Nguyen.
Thank you. May it please the court, my name is Mary Nguyen on behalf of the Commonwealth. With respect to the first issue regarding closing, the defendant has made a number of claims about various statements by the prosecutor's closing argument. In sum, the Commonwealth's position is that when analyzed in the context of the entire argument, along with the judge's instructions and the evidence presented at trial, these statements were supported by the evidence and the reasonable inferences therefrom. You can see from my brief that I organized counsel's arguments sequentially in my brief with respect to the closing. And I think that's important because I think the case law is clear that the prosecutor's closing should be read as a whole. So unless there's a specific argument that you want me to address first, I will now in turn address them sequentially as I did in my brief. And that would be the first argument would be with respect to the prosecutor's statement regarding the defendant being present with Ace at the scene of the crime, and then also the statement of the neighbor. And turning and spending more time on the statement with regarding the neighbor, that Ace stated, "Here come those white mother effers, let's get them." The Commonwealth acknowledges in its brief that that unfortunately was an overstatement. It was a reflection of what actually happened, the actual conduct of the joint ventures and the defendant, not what was actually said by Ace. But nevertheless, when you do the analysis, the misstatement was not prejudicial. And just pointing out initially, as an initial matter, the reference "let's get them," it was brief and isolated and comprised only a small portion of the prosecutor's closing argument. There were 3 references in 2 pages of the 24-page closing argument. But more importantly, when you're analyzing the factors on whether or not there was an objection, so whether or not it created prejudicial error, the fact that there was evidence that the defendant actually ran after or ran towards the victim to in fact get him along with his comrades is more damning, I would suggest, than any statements that Ace said. So in essence,
for me, the only really difficult statement by the prosecutor is the "served him up on a platter to be carved up" statement, which suggests not merely that the defendant held the victim in a way that created the opportunity for Ace to stab him to death, but that he intended to do so. That is, he deliberately served him up on a platter so that Ace could kill him. Is there, what do you say about that statement? I mean, there's an objection right in the middle of it. You know, it's clearly preserved, it's overruled.
so I'll move on to that. So I just want to first note that that's hyperbole, but getting into sort of the substance and in your question with respect to the argument regarding intent, regarding the positioning, the argument regarding the positioning of the victim's body.
No, I want to talk about the closing first. That's sufficiency. We'll get to that in a second. I want to talk about the intent. Let's assume that it's true that he held him in such a way, it must be true, that it doesn't must be true, but if he's guilty, it's true, that he held him in such a way as to expose parts of his body that Ace was able to stab. If in fact he was stabbed while he was holding him, that must be true. If those parts weren't exposed, they couldn't have been stabbed. So a bunch of what the prosecutor says sounds a little like that. It's close, but it sounds like what he's saying is this permitted the crime to take place. This in fact facilitated the crime, without saying that was why he was holding him like that. But then when he gets to, he served him up on a platter so that Ace could carve him up. That says to me, this was the plan. You hold him like this, so I'll be able to stab him to death. And I'm asking you, is that an error? Is that a supported inference? Does it matter?
Yes. So, Your Honor, I would argue that first it's hyperbole, but moving on from the hyperbole.
It's hyperbole. If you mean by it's hyperbole, it's not true, then okay. All right, then now it's not true. It's an overstatement, is what you call the other mistake the prosecutor made. I think it's not mere hyperbole. It's substantially different to say this permitted the stabbing to occur than to say this was done so the stabbing could occur. And I want to understand, calling it hyperbole doesn't really get me anywhere because it's different. It's not like a turn of phrase or something. It's a different idea to me.
So if I can unravel that a little, the Commonwealth's position is that the jury reasonably could have inferred from the defendant's statement that his actions in holding DJ in a chokehold such that it allowed Ace to stab DJ in the areas that were exposed, that was an inference that could probably be drawn from the evidence. So even if you just consider the defendant's statements, he essentially stated he put the victim in a certain position, and you can draw the inference that from that that he did so that Ace could stab him. So the defendant, as you had indicated, Your Honor, essentially told the police that he grabbed DJ's neck and then he wrapped DJ's left arm up and the defendant positioned himself behind DJ and then wrapped DJ's own left arm around DJ's neck and then placed him in that sloppy chokehold. And then he went for DJ's right arm.
Sure.
And then the defendant indicated he stepped back. So he's behind DJ so in that chokehold with DJ's own left arm. And at some point, whether you believe he put DJ down, that version, or if you believe that DJ tripped as he's being led backwards with the defendant behind him, he falls and he's on the ground. The defendant says he keeps the victim on the ground, and then he sees a pool of blood. And then the detective also asks him, so at some point during that he was stabbed, correct? And DJ acknowledges, yes, he was. And then he tries to indicate that the victim may have stabbed himself. But from that evidence, from those statements, even just those statements alone, those admissions, those statements about putting the victim in a certain position, the jury certainly could draw that inference that he did so.
Was there any evidence that he knew that Ace had a knife?
So that's also the Commonwealth would argue is not relevant to the question of voluntary manslaughter. And so I'm kind of moving a little bit to the sufficiency argument.
I agree with that, but you just said that there's evidence that he held him in that position so that Ace could stab him. If he doesn't even know he has a knife, then he's certainly not doing it so that Ace can stab him.
So, well, you might have noted in a portion of the Commonwealth's closing that she noted to the jury, which it's certainly an evidence and draw the inference, reasonable inference, that he can observe at this point, right? It's that inference that the stabber Ace was in front of the two parties, the defendant and the victim, and that the defendant is closer. He can see the stabber Ace. He's even closer than Miss Simus was, right? And Miss Simus testifies from her vantage point that Ace pulls out an object and stabs the victim 3 times. So there's the suggestion that from where how close the defendant is with the stabber facing him, that he did in fact observe the stabbing.
Okay, now let's get to shared intent.
Yes.
Just going off the argument and on to the substance of it. And as you've said, and I agree with you, he didn't need to know that the defendant, that the stabber, Ace, had a knife to be convicted of this joint venture. He had to share the intent, right? And that
sorry, I apologize.
That intent is the intent to do something to the defendant that would likely result in death. Is that right?
It is the shared intent.
Yeah.
It's Your Honor, the shared intent to intentionally inflict an injury or injuries on the victim likely to cause death.
Likely to cause death. All right. So what support do you have for intent to do so?
Yes. So a case that I cited in my brief is Commonwealth versus Shim. And Shim also cites another case, Commonwealth versus Semito, which is different from the Semito case that I cited in my brief. So I just want to give Your Honor the citation for that. It's 422 Mass 716, a 1996 case. And I kind of refer to it loosely as the Tasty Chicken restaurant case, because that's where the incident occurred at a Tasty Chicken restaurant in Dorchester. But the language and the fact pattern in both of those cases are very similar to this case here, although those cases were first-degree murders. Those are instances where there was a group attack on the victim, on the sole victim, and it was a perpetrator other than those 2 defendants that committed the stabbings. So in both cases, neither one committed the stabbings, yet the SJC in both cases stated that evidence that the defendant participated with other men in a brutal beating on the sole victim, and that the defendant battered the victim's head and body by means of a shoe. This is Semito in particular. The jury reasonably could have concluded that the defendant's intention was to inflict injury, and that his intention was coupled with an awareness that death might result from the injuries he participated in inflicting.
It has to be, in our case, likely. Right?
Yes,
It has to be likely to result.
So the standard's a little bit lower on a voluntary manslaughter.
Are you saying he kicked him, which there is evidence he kicked him, and that's where you get the inference of intent? That is, he participates in the beating. No one is saying what he did was likely to cause death, I don't think. It's the knife that's likely to cause death. But you think the jury can infer intent not merely to inflict bodily injury, but to do something that will likely cause death from the participation in the fight. Is that?
Yes, because both, like the SJC articulated in Shim and that Semito case that's cited in Shim, which is different from the one I cited in my brief, the fact that there was a vicious beating of one man by several assailants creates an inference of that intent, that at least in this case, that the injuries, that the beatings, if you will, were likely to cause death.
So you're saying that the likely to cause death is the kicking, or some aspect of the beating together? Or are you saying we simply infer someone who's beating the daylights out of someone? The jury can decide. It's a fact question. They can decide, well, maybe he only had the intent to kick him and not kill him. Or maybe he had the intent to do something that was likely to kill him.
So I'd ask Your Honor to look at both cases, both Shim and then that Semito case, the Tasty Chicken case. Shim is a little bit more sort of broad in its language by saying a vicious beating of one man by several assailants creates an inference of intent, at least to do an act which could create a plain and strong likelihood of death, in that case, the first-degree murder. And then Semito actually is a little more specific, where it actually references the fact that the defendant in that case battered the victim's head and body with a shod foot, which is similar to our case, and says that based on that participation of those specific injuries, the battering of the head and the body of the victim, that was sufficient for the jury to reasonably conclude that the defendant intention was to inflict injury, coupled with the awareness that death might result from the injuries he participated in inflicting.
But the first case, though, will show that is not mere speculation on the part of the jury, but that a finding is supported by such evidence. Even though, of course, we can't really know what's inside the guy's head, that the jury can draw that inference, and it's a jury question. Is that right?
Yes, Your Honor.
All right, your time has expired. Thank you very much to both of you. This is very helpful for us. And I think we understand your arguments even better today. We have your briefs as well.
The case is now being recorded.
Good morning. Welcome to the Appeals Court, everyone. I am Justice Rubin. I'm joined today by Justices Singh and Hand. We are hearing this by teleconference due to the ongoing pandemic. The rules of argument are the same here as they are in our courtroom, which is to say 15 minutes per side with no rebuttal. The next case we will hear is number 19-1558, Commonwealth versus Richardson, and we will hear first from Attorney Weber.
Thank you, Your Honor. Philip Weber, representing Mr. KEYARN Richardson. Mr. Richardson's case is here today because a motion for required finding should have been granted, as there was insufficient evidence to convict him under joint venture.
Can I just ask one question, Mr. Weber, before you get started? Am I correct in understanding that you're not, your client's not appealing the possession charges, just the joint venture related charges, correct?
Well, most of the arguments are focused in regards to the assault and battery charges. It's essentially, the argument is that the motion for required finding in general should have been granted. So while I certainly acknowledge that most of my argument was focused on the assault and battery, honestly, in regards to the entirety of the charges against him are indeed being appealed. The motion for required finding in general should have been granted.
Did you brief anything to do with the possession charges?
It was indeed focused on the assault and battery charges. The vast majority of the argument was indeed focused on the assault and battery charges against him, as it is the central focus of the argument.
Thank you.
Thank you, Your Honor. So as Your Honors are aware, for joint venture, it must be shown that Mr. Richardson would have aided, commanded, counseled, or encouraged the commission of the crime while sharing with the principal the mental state required for the crime. Now, indeed, starting with the mental state, Mr. Richardson did not have the knowledge or intent needed for joint venture, as there was a lack of evidence showing that Mr. Richardson knew what was going to happen. Now, looking at the evidence in the light most favorable to the Commonwealth, as we must with a motion for required finding, the most significant piece of evidence in that regard would have been the testimony from police officers that Mr. Richardson chambered the gun and handed it to Mr. Williams. Although that piece of evidence, there is some conflict in there, as two different police officers testified in regards to kind of two different places that they saw Mr. Richardson chamber the gun and hand it to the perpetrator. One said he was behind a dumpster, one said it was a little later. So there is, even in the light most favorable to the Commonwealth, it's not really certain which piece of that evidence we would need to focus on. But even so, the idea being that he would have chambered the gun and handed it to the perpetrator. The thing is, that does not show that he was aware of exactly what's going to happen. There's a lot of different reasons that a person would want to have a gun with them. I mean, obviously, self-defense amongst other ones. He may have just wanted to have his gun on him. I mean, it's very hard to know with certainty. Just handing him a gun means he knows that he's going to go try to shoot at these specific individuals. And indeed, there are cases, for instance, such as the McKay case, in which the defendant in that case saw a bulging backpack, saw the perpetrator enter a house 2 times at night, and even had questions about a barking dog. And even though McKay, there would have been enough to possibly reach the conclusion that the defendant there knew what was going on in regards to the robbery, the court ruled that it was too inconclusive to show that. And I would argue that the same can be said here. It's one possible option, maybe, in regards to handing a gun, but that is certainly not enough. Also, even the Lombard case shows that even when it's possible that the defendant would have the requisite knowledge, that possibility and suspicions are not enough, that the Commonwealth must present evidence for the jury to find beyond a reasonable doubt that there indeed was enough for a joint venture. And I would argue that in this case, there was not that level of evidence. And the other pieces of things that are pointed to try to show Mr. Richardson is aware of what was happening, I would argue, well, don't. The idea that he was kind of looking around, the Commonwealth argued that he was acting as some kind of lookout. But there indeed is case law talking about the fact that just looking around in general does not show that he was being some kind of lookout. And indeed, if he was being some kind of lookout, obviously he wouldn't have been very good at it. There were multiple police officers watching them at the time. So it's kind of hard. If the bare minimum, he would have been lousy at it. And really, it's more along the lines of just, it's an innocuous action. You're walking down the street, you look around a little bit. That's what the case law talks about, that indeed is a quite innocuous action. And all of the actions following the shooting, I'd argue, really don't show anything, because once the shooting actually takes place, well, by that point, Mr. Richardson's aware, well, anyone who's in the area is aware of what's going on. Anyone who's in the area here's gunshots, know that there are gunshots being exchanged. So by that point, you don't have to be involved in any way, shape, or form in order to know what would happen is going on.
You can take into consideration actions that happen after the fact, right? It's appropriate to consider actions after the fact to give you an idea of the awareness before. Is that appropriate?
As a general proposition, yes. But in this specific scenario, I would say that the actions after the fact do not show that he had any knowledge before the fact. Because once after the fact, what happened is he starts running. Well, there's gunshots. It's not exactly unusual for him to run. There were arguments about him being evasive towards police. However, Mr. Richardson does have a prior record. And indeed, there is case law talking about the fact that a Black man with a prior record who has just been in the middle of a gunfight, being a little scared, not wanting to talk to the police, that doesn't show that he knew what was going to happen beforehand. That shows that he was scared after the fact, that he didn't want to talk to the cops after the fact, which, considering the circumstances, the prior record, the gunfight, a young Black man, this is not something that should be seen as shocking. Even when he gets to the point where he's at the hospital, in fact, the hospital part is also a little bit confusing because the Commonwealth contends that he was at the hospital with a supposedly self-inflicted gunshot wound, but that doesn't actually really make sense in regards to the fact pattern that the Commonwealth presents, because their argument is he hands the gun to the perpetrator, then a gunfight breaks out. So I'm not even sure how he could have possibly self-inflicted a gunshot wound when he handed the gun to someone else and there was no evidence of a second gun. So unless he hands the gun to someone else, a gunfight breaks out, and then that person
except for the gunshot.
Well, then that wouldn't be self-inflicted. Then it would have been just him being shot.
I don't know. I mean, I don't think this really gets to the heart of the case, but if the angle of it or something indicated that it was self-inflicted, then unless that bullet matched, if they retrieved a bullet, which I don't think they did, matched the original gun, maybe it came from a second gun. I mean, I'm not saying it's important to the case because I don't really think it is, but I mean, right? So
I just pointed out, as regards to the facts, is, we take the facts in light most favorable to the Commonwealth, but even in light most favorable to the Commonwealth, the facts need to make sense. They need to certainly add up. And if it's self-inflicted, it doesn't make sense for the reason stated. And if it's not self-inflicted, well, then he was unlucky and he happened to be in the middle of, an area where there was a gunfight going on and there's bad luck. And the idea that later on, while at the hospital, he wouldn't want to tell the police about what happened doesn't suddenly mean he knew what was going to happen beforehand. It again goes to the fact that a young Black man with a prior record doesn't want to talk to the cops. I mean, that's really, fairly straightforward. And I don't think there's anything about those actions, anything about that would indicate that he was aware of what was happening beforehand. Now, moving on to the other part, whether or not he would have participated in a meaningful way. Now, clearly, if he didn't have any knowledge, then it ends there. But for the sake of argument, whether or not he would have participated in a meaningful way, because that is required, as your honors are aware, for the sake of joint venture. Now, as has been stated, his looking around is not enough to show that he actually acted as a lookout, as the Commonwealth would attempt to argue, as I've stated before in regards to that. So really all this comes down to is, at most, Mr. Richardson would have handed a gun to Mr. Williams, the perpetrator. Now, there was no evidence presented that Mr. Richardson supplied the gun. There's no evidence presented that he was the one who got the gun in the first place. So that would be complete conjecture in that regard. So really all we have is handing him a gun, passing something to him. That is not enough. That is certainly not enough of a significant act to participate in a meaningful way. I mean, that's really to the point of just passing something on. I mean, if I pass somebody the salt at the table, I haven't participated in a meaningful way to raising their cholesterol. I've simply just passed something to them. It's something that if he doesn't pass it to him, Mr. Williams would have just as easily been able to reach and grab the gun himself. It's not as though him passing the gun.
I mean, I appreciate you have to make the best argument you can, but it seems to me that if he had the proper intent, chambering a bullet so the gun is ready to be used in an assault and handing it to someone seems like meaningful participation to me, doesn't it? I mean, I mean, obviously, I'm not really asking you to concede that, but he didn't just hand a gun. And even if he did just hand a gun, well, he handed a gun to a guy who used it in an assault. I mean, I don't know. But chambering the bullet and handing him the gun seems even more, here, this gun is, because of my act, this gun is immediately ready to use. That seems to me like meaningful participation.
I mean, I would argue that it's not as, even chambering a bullet is not some significant action. You know, guns are, at least in regards to that element, I'm not going to claim to be an expert on firearms, but chambering a bullet is a fairly simple act. It's not as though we're looking at a scenario where if Mr. Richardson hadn't been there, this doesn't happen. I mean, it's not like taking Mr. Richardson out of the equation suddenly changes everything, suddenly makes it so that it's not possible for everything to take place, that it's not possible for the actions to occur. It really just puts it in a place where it's such a small, minor thing that without Mr. Richardson there, everything still happens the exact.
But that's not the standard, right? Whether the crime could have been committed alone, and you can't be convicted as a joint venture because they could have done it by themselves.
Well, I'm not arguing that it's the only factor to consider. As Your Honor is correct, that's not the standard. I think it's simply illustrative of what indeed does constitute a meaningful participation. I think it helps us to understand whether or not there was meaningful participation in regards to Mr. Richardson's supposed part in this action. Because just while Your Honor is correct that it doesn't have to be, could it have happened without the person there, it at least helps shine some light in regards to the idea of it's such an innocuous, it's such an insignificant act. I mean, that's really the heart of it there, that it would be such an insignificant act overall that at such a level of insignificance, it's kind of hard to say that it would be a meaningful participation. I mean, primarily, I believe that the knowledge factor is, in this specific case, more significant in regards to it, because obviously if he doesn't have knowledge, then meaningful participation doesn't really even matter. But I do believe that that action is ultimately not a meaningful participation in the offense. Unless Your Honors have any more questions, I would rest on my brief.
I see none. Thank you very much for a very good argument on behalf of your client. We will hear now from Attorney McClellan.
Thank you, Your Honor. Good morning. May it please the court. Ian McLean on behalf of the Commonwealth. Your Honor, I'd like to begin by first recognizing two people that I understand are watching the live stream via YouTube. First, the trial prosecutor, Assistant District Attorney Caitlin Fitzgerald, and second, Taylor Morgan, a law student at Suffolk who participated in the brief in this case. This court should affirm the defendant's convictions because examining the evidence in the light most favorable to the Commonwealth, there was ample evidence to establish both the elements of the firearm possession offenses as well as that the defendant was engaged in a joint venture to shoot at the victims here. I'll turn straight away to the joint venture as my brother spent the majority of his argument discussing that. As the court well knows, we're basically looking at knowing participation and shared intent. So here, I would say that knowing participation came from four categories of evidence. The first would be that he provided the gun, ensuring that it was loaded in so doing. The second would be that he, after providing the gun, he left from their, what we would characterize as a hiding place, crouching between two cars, traveling down Morris Street to the location where the gun shootout occurred. The third category would be after the shootout had occurred, fleeing with the shooter. And the fourth category being consciousness of guilt when they interacted with officers during their flight from the scene. So those are the four categories of evidence that the Commonwealth would say established the knowing participation. So running through them really quickly with the evidentiary support for each. First category, that he provided the gun, ensuring that it was loaded. Officer Kaplan observed him the two co-actors together, the defendant and the shooter Williams, crouched between two vehicles on Moore Street. That's transcript 358. He observed the defendant draw the gun from his waistband. That's 397. Pull the slide back to chamber around and then pass it to Williams, who ended up being the shooter. And that's 358 to 59. Once he had passed the instrumentality of the crime to Williams, he then left their hiding place crouched between two cars, traveled down Morris Street with the shooter to the scene where the shots were fired. You can find that at 373. Moments later, the gunshots rang out. Multiple officers heard the gunshots, 334, 360. And the defendant ultimately admitted that he was there with Williams present at the scene, 367. After the shootout occurred, where there were 10 rounds fired from the Smith & Wesson .45 caliber handgun, the defendant fled with Williams from the scene, and that's at 353 and 69. And then when they encountered police officers, once they had made it back to their vehicles that they had used to drive to the location on Brinsley Street, instead of requesting emergency medical assistance because he had been shot, the defendant attempted to distract the officer and then fled from him. And so I would point you to the Porter case, where actions designed to deflect attention can be interpreted as consciousness of guilt. And then here, the continued flight, not only from the scene, but now from officers. Again, flight is a demonstrative of consciousness of guilt. My brother argued that there were alternative explanations for the flight based on his prior criminal record or just general fear. And I point the court to Fuentes here, where the jury can infer guilt despite alternative possible explanations. And as this is a sufficiency argument, we're looking at all this evidence in the light most favorable, and we have to draw all reasonable and possible inferences in favor of the Commonwealth. So here, the flight from the scene, and then combined with the distracting statements to the officers and the continued flight from the officers, from that you can draw the jury could draw the inference of that was consciousness of guilt of participation. Essentially the same categories of facts establish the shared intent to commit this offense here. The highlights again being the crouching between two cars on Morris Street, in order to draw the weapon, chamber the round so that it was ready for use, and then pass it off to Williams, who was the shooter, and then departing their, what I'll call secreted location with the shooter and traveling with him down Moore Street to the location where the shots were actually fired. So that establishes our joint venture requirements of knowing participation and shared intent. The other really brief requirements here would be, it is an assault and battery by means of discharging a firearm, so it would be the attempted touching, the discharge, and the firearm would be our other elements. Here, the attempted touching, we have 10 shots that were fired, and we know that because 10 shell casings were recovered from the location. And through the ballistics testimony, those shell casings were matched back to the Smith & Wesson .45 caliber handgun that the shooter, Williams, threw when they encountered officers during their flight from the scene. So we know that the discharge occurred. The ballistics testimony established that Smith & Wesson weapon handgun qualified as a firearm, as the barrel length was, I believe, was 4.5 inches, so that's under 16, and it was test fired and was capable of discharging rounds. So then the third element, the attempted touching, again, we have 10 shell casings at the scene, combined with the officers in the area that heard the shots fired, and the testimony that there was a group of people right there in front of 7 Moore Street. So that satisfies our attempted touching element. So here, the elements of the offense were established, as well as the additional elements as a result of joint venture, that of knowing participation and shared intent. If there are any questions, I'd be happy to answer them, or Justice Hand, if you would like me to address either of the possession of firearm offenses. That we briefed the issues, even though they weren't fully argued by opposing counsel.
Thank you, Mr. Weber. I think addressed my concerns on that.
Okay, thank you, Your Honor. If there are no further questions from the court, the Commonwealth will rest. Thank you, Your Honor.
Judge Rubin, I think you are muted.
Hi, sorry. Seeing no further questions, as I tried to say moments ago. Thank you very much. I think we understand both of your arguments. Excellent job in both your briefs, and I'll eventually, once we're up and recording, I'll call the case.
case is now being recorded.
Good morning. Welcome to the Appeals Court. I am Justice Rubin. I am joined today by Justices Singh and Hand. We are meeting by teleconference due to the ongoing pandemic. The rules for argument are the same here as in our courtroom, which is to say 15 minutes per side with no rebuttal. I gather that the appellee side will be dividing their time. Correct me if I'm wrong, please. DCF will take 10 minutes, followed by the child with 5 minutes. Is that your understanding as well, Counsel?
That is correct.
Okay. I would remind everyone that this is an impounded case and that you should use titles, father, child, and so on, rather than anybody's name. And the case we will hear next is number 20-651, Department of Children and Families versus Father. We will hear first from Attorney Messer.
Thank you, Your Honor. Good morning, Your Honors. May it please the court. My name is Dawn Messer, and I am arguing on behalf of the appellant father. Father appeals from a decision of the Taunton Juvenile Court finding him unfit for daughter, terminating his parental rights, approving the DCF adoption plan, and ordering no post-termination or post-adoption.
I'm sorry, we're having a technical problem.
The trial judge relied
Messer,
upon findings weighted by exaggeration.
Attorney Messer, can you hear us? Can you hear me? Attorney Messer. Oh, we have a problem.
Yes.
Okay, so we have a very bad connection with you for some reason.
Can you hear me, Your Honor?
We hear you on and off, and your video is frozen on and off. I don't know why that is. It may be your connection, or it may be something more fundamental. We've stopped the clock, as you can see. I'm not sure what to do about this.
Would you like me to put the attorney back in the waiting room and then readmit her?
You mean after she reconnects?
Oh, I don't know.
Well, I don't know how that would help. Just by
Let me
itself.
try to,
I don't know
yes,
if you.
may I try to locate a better space
Sure.
for the connection?
Of course. Why don't we, yeah, why don't you do that? I don't want to disrupt your argument. We'll start, I mean, we're only
Okay,
40
just
seconds.
1 minute.
So,
Should I start at 14 minutes, Judge, or 15?
15 is fine.
Okay, just 1 moment. Hey, Jamar, this is not working. The internet, yeah. It's working right here, but not back there. No, it's, I can try.
Matt, why don't we pause the recording for a minute while we end the live stream while we get this sorted out. Call the case again so that the recording has the case number on it.
If you would, the first one did have it, but I mean, this is a
Yeah.
second recording.
All right. So we'll begin again and I'll call the case.
The case is now being recorded.
The next case we'll hear is an impounded case. I remind the attorneys not to use the names of the individuals involved. It is number 20-651, Department of Children and Families versus Father. And we will hear first from the attorney for the father, Ms. Messer.
Thank you, Your Honors. Good morning, Your Honors. May it please the court. My name is Dawn Messer, and I'm arguing on behalf of the appellant father. Father appeals from a decision of the Taunton Juvenile Court finding him unfit to parent his 3-year-old daughter, terminating his parental rights, approving the DCF adoption plan, and ordering no post-termination or post-adoption contact. The trial judge relied upon findings weighted by exaggeration, speculation, and an incomplete review of all of the evidence. As a result, several of the critical findings were clearly erroneous. The balance of the evidence was not clear, positive, and free from doubt, and the court's ultimate determinations were an abuse of discretion. The trial judge's decision to find father unfit and to terminate his parental rights revolved around her belief that he was a lifelong criminal, unable or unwilling to extricate himself from a dangerous lifestyle. In making this determination, the trial judge exaggerated father's criminal record, improperly considered juvenile court charges, and summarily dismissed uncontested evidence of father's benefit from services and the possibility for parole in 2020. Speculating that father's motivation to attend programs aimed at reforming criminal behavior was solely to receive good time, the trial judge dismissed all indications that father benefited from services. Without explanation, the trial judge ignored the social worker's testimony that during her work with father over the year prior to trial, and I quote, "He showed a lot of insight, talking about things he went through when he was younger versus now, and why would he want to revert back to that lifestyle. Father would like to move forward, and I quote, he was excited about getting his GED, talking about the future and things that he wanted to do for his future." The trial judge did not find the social worker not credible, nor was there evidence to contradict her testimony. Father testified in detail about classes educating him on addictive behaviors, ways to avoid criminal thinking, victim impact, and strategies to stay on track and not revert to the negative thinking that was causing the criminal behavior. Father acknowledged that he enrolled in the Constructive Recovery Academy for a good time, but that he was, I quote, "getting a lot out of it because he learned that a person can be addicted to anything. And while he wasn't addicted to drugs, he was addicted to the lifestyle that he was living."
Counsel,
The trial judge
wasn't
Yes.
father, I mean, one of the key issues is that the father was simply unavailable for the child for the majority of her life, her short life.
Yes, so part of that was that was part of the evidence, but in order to find father unfit for the indefinite future, the judge had to look at what his circumstances were at the time of trial, whether he would be available at any time in the future, and whether when he was available, would he be fit to care for his daughter. So while the past is certainly something that needs to be taken into account, that cannot be the only thing that the court considered, because if it was, it would frustrate the purpose of parents doing services at all. If we only look at the past and not, then then parents would not be motivated at all to improve their lives in order to care for their children.
What was the date of trial?
What was the date of
Trial.
time for what? Oh, the trial ended in July of 2019.
And when was he arrested on the gun charge?
Yes, September of 2017.
And are you saying it was clearly erroneous for the judge to find that he would be released in 2023?
Yes, because there was specific evidence, both in the DCF record, that he might be eligible for parole in 2020, and he testified himself to the good time that he was earning by participating in the classes, which would bring him forward
what is the evidence
closer than the 2023 date.
What is the evidence of parole eligibility?
So the evidence of parole eligibility was both father's own testimony and the social worker's statements in her court report. There weren't any documents admitted regarding the parole eligibility, but there wasn't anything to contest that father participating in these programs was not giving him good
Do we
time.
know what he was convicted of?
Yes, his criminal record details all of the charges, and I can bring that record up for you if you'd like.
No. Do you know if any of them have mandatory minima?
So I do not know the answer to that, but I certainly could look into that and let you know.
Good, just as well. I mean, I see there's testimony that, or evidence that he might be eligible for parole. The judge may have known better than that. I mean, I don't know. Certainly, you could take judicial notice of the, you know what I mean, of the mandatory sentence for something someone was convicted of, for example.
Yes.
And if he's not being released till 2023, your argument about indefinitely into the future is substantially weaker, isn't it?
Well, I would agree on behalf, if he was not going to be eligible for parole or release until 2023, that certainly puts him much farther out in terms of years being unavailable.
Have to let this 3-year-old live for 4 years in limbo. I don't see how that is. That seems indefinitely into the future enough for me to, right?
But I understand Your Honor's concern. What I would say, though, however, is that where it was unclear if he would be released in 2020 or shortly thereafter or 2023, the court had to look at the other alternative options.
The judge made a finding that he'd be out in 2023. Now, if that's clear error, that's one thing. If it's not, then it's not.
Should the judge be basing this decision counting on him being paroled? Just because he's eligible doesn't mean that he will be paroled. And we have some evidence in the record as to how he's been doing in prison.
Yes, and that's, I agree with Your Honor that you can't count on him being paroled, but that's why the alternatives to disposition are so important. And I will bring the court to that argument next, if you like. So the court had 4 options when deciding whether to terminate the father's parental rights after finding him unfit. So just assuming that he's currently unfit because of his unavailability, now the court has to look to what is the positional option. So there were 4 choices the court could have made. One was termination of parental rights and approving the adoption plan of the department. That was one choice. And that's what the judge chose. But there were 3 other alternatives that the judge could have chosen that would have both protected the child currently and allowed father to continue his progress that he was demonstrating, so that he could either show that that was going to be sustainable or that he could no longer sustain that. And then the option, the beauty of the option on all the other 3 is that the department or the child or the father could come back to court 6 months later and say, listen, he has not been paroled. He's not doing well while he's incarcerated. So now we need to go forward to terminate parental rights. So the father
judge did go through those options, and he detailed why the other options were unacceptable.
Well, what the judge, but the judge's basis for determining that they were unacceptable was a belief that he would never be able to reform or sustain his progress.
I think your client's proposition was to have the child with his mother.
That was one option, yes.
Right, and the judge, on the merits of that petition, determined that that was not the favored option for a variety of reasons, not because your client would never be released, but because of the suitability of that option, the suitability of his mother taking care of the child. Was there anything?
So what I would say to the court is that that was one of the options that was presented, and father's argument is that the judge colored that up, her dislike for him and his criminal activity and his potential for, being a
question is
yes.
the child's best interest once he's found
Yes.
unfit. The fact that it might be helpful to him, let's put the kid on hold while we wait and see if I behave in prison. Although I've already been placed in segregation, my recollection is, notwithstanding your characterization of how great he's doing in jail, put the kid on hold and we'll see if I get released in a year and a half or a year and whatever year. And that may not be, that might be in his best interest, maybe, but I don't see why there's anything compelling us to conclude that that's what's in the child's best interest. I mean, the child has almost no contact with this father ever. This isn't a situation where the father was the primary caretaker and then in a one-off event, somehow something crazy happened and he wound up in jail, right? He spent almost no time with this kid and he took knowing, conscious action while he was one of her caretakers to absent himself for 4 to 6 years. So,
And I would just argue to the court that there are many, many parents that don't have involvement with their child for years leading up to these cases. And when they do appear and they do show that they are interested and dedicated to their child, then the court has to look at that information and to see whether or not, or a probability.
Can you
that,
hear me? Attorney
yes.
Messer? Okay. He has not shown any dedication to his child. I don't know why you say he has. He had joint custody of her apparently, or at least was living with her and the mother together. And instead of caring for his child and being dedicated to her, he had the mother bring him a gun. I don't know if he shot somebody or he fired shots and nobody was hit. And he was taken away shortly thereafter for 4 to 6 years. That's not how you show attention to your child. Commit a crime while you have care and custody of them so that you can go away and be, they can be without you.
So I agree. The action itself is not something that is designed to care for a child. But if you look at what he did prior to when he was living in the home with the mother and did so in a way that the social worker found was
Well,
so in a way that the social worker found was very caring and nurturing.
Counsel, the social worker
that might be outweighed. Well, go ahead. I'm sorry.
No, that's okay. Had a single interaction in the home, correct? One visit in the home. And then the father needed to take a break and left the home before the arrest took place, correct?
Yes, he did. And in reality, parents get overwhelmed. And this is a father who had just been released from jail. And he was readjusting to the world and taking care of his daughter. And it's understandable that somebody would feel overwhelmed, and he knew that he needed to step back and take a break.
And then put the mother and himself at risk of incarceration within 2 days by asking her to bring him a gun, which she did.
Yes,
I mean,
that's correct.
Yeah.
That's correct. But I would say to the court that what he did, and maybe it's kind of like that, you have to hit rock bottom before you can come out of it. And in jail, he has been able to take advantage of things that he maybe didn't have access to
but
before.
He's also I'm right that he's been put in segregation, right?
But not since September of 2018.
Putting him at risk of not being paroled.
That's correct, but it had been almost a year since he had been in segregation or had any mental health episode before the trial ended. So he had demonstrated demonstrated a long period of time before the trial ended, showing that he was trying his best to reform himself, learning from the programs that he was participating in, and trying to plan a life that was better outside than he had before. So I see my time is up. Thank you all very much.
Thank you, Attorney Messer. Very good argument on behalf of your client. And of course, we hope that he does well both in jail and afterwards.
Thank you. If you wouldn't mind, could I place myself on mute so you don't have distractions from the background? Thank you.
We will hear next from counsel for the department, and that is Attorney Ada. Attorney Ada?
May it please the court. Assistant Attorney General Lila Atta. I represent the Department of Children and Families in this matter. And we ask that you affirm the lower court's order and decision, not only finding father unfit, but terminating his parental rights and finding that the department's plan was in the best interest of the child, along with an order of no visitation was also in the best interest of the child. The trial court properly found that father was unfit to parent the child based on clear and convincing evidence. This was supported by findings of fact that were established by a preponderance of the evidence. And father's main argument throughout the brief essentially is arguing over the weight of the evidence that was attributed to the judge and findings of credibility in this. The department's position is that the trial judge's findings were absolutely not erroneous, and that in fact the evidence at trial of father's unfitness was overwhelming. This was based on the history of father's criminal involvement, incarceration for approximately for incarceration for all of approximately 2 to 3 months of the child's life, gang involvement, keeping a loaded stolen firearm in a box in one of the bedrooms of the family's home, and unavailability or lack of involvement in the child's life pretty much for the duration of the child's existence. Now, turning first to the unfitness categories that father was arguing were erroneous in this, I would say that the judge's findings were completely grounded in evidence that was presented at the trial. Father argued that the judge did not credit any type of positive information about taking care of the child, lack of law enforcement, cleanliness of home, cooperation with the department, or improved mental health. However, the record is completely clear that this wasn't at all what the judge did. In fact, the trial judge took into account all of the positive gains, but rather also paid attention to all of the evidence, including the negative evidence that was presented against father. We would also argue that father's interpretation of the way that the evidence was presented was not necessarily an accurate interpretation of how this evidence actually came into being. Starting with the taking care of the child. Now, father placed a great deal of emphasis on this one visit that took place in the presence of the social worker. However, this was simply one visit. This was one time in which the social worker did appear after father had been released and was living with mother and child. During this very short interaction, he was seen in what was described as a gentler and nurturing manner, but this was one interaction and that was it. And the trial judge is not bound to consider this one interaction in determining how father has parented child. And in fact, there was other evidence that wasn't presented in father's brief that we believe is completely indicative of how he was caring for this child. And that has to go with the cleanliness of the home. The social worker was able to see during one of the visits, and this is while father was actually at home with mother and child, that the home was in disarray, that there was a broken lock, and the social worker actually had concerns with the fact of the way that the home even smelled and the fact that it was not being taken care of. We believe that this is actually showing how this father is taking care of this child. This is the home in which father is raising this child. We also take into account the fact that after the child was removed, there was a search warrant that was executed in which the home was still in complete disarray. There was so much as feces on the ground at the time when the police officers executed the search warrant. And while father wanted to contend that this was 11 days after, This actually wasn't. It was, yes, in terms of 11 days after he was physically away from the home. However, he had only been out of the home approximately 2 days when both him and mother were arrested, narrowing the time frame significantly down from the 11 days to only 2 days. We would also talk about the cooperation with the department. And Father wanted to give much credit to the classes in which Father has taken, and wanted to say that the judge's findings were erroneous because she did not take into account any type of positive gains in this manner. However, it was simply the words of the defendant. Those were the only things that were actually any type of, and I would put this in quotes, any type of benefits that were derived. We have no information of how Father has actually improved as a parent. We have no information that he has actually bettered himself in any way, but just simply saying what he hoped to accomplish in the future, or what he believes that he has learned in this. But when you actually look to Father's actions, you see that he's still he's still participating in illegal activity. He's not outside in the world committing crimes and committing violations of probation, as he has been shown whenever he was out of incarceration. But even while incarcerated, he is going back into segregation. He's having illegal items found in his bunk room, and he's being punished for those types of behaviors instead. Also,
Is your sister correct that the last time that happened was a year before trial?
I believe that was approximately 6 months, maybe 5 months before the trial began. The trial did conclude, I believe it was in July, but the trial began in February. The trial spanned over 4 days, but this was taken approximately, I believe it was around 5 months in which these 4 days of the trial actually did take place.
Do you shed any light on whether the judge's finding that Father will be released in 2023 is clearly erroneous or not?
I do not believe that it was clearly erroneous in this. It was shown that he was arrested in September of 2017. He was sentenced in April of 2018. However, we would assume he would get credit for that entire amount of time. And sure, if his term of incarceration was for 4 to 6 years, he would be, and the judge used the term released, that would be at the 6-year mark, which would put him in 2023. There was no information other than the father's stating that he had 60 days worth of good time, and then said that there were a couple conflicting statements that he believed he would be eligible for parole in the summer of 2020. There was never any information that came from the Department of Corrections. There was never any information about what time he actually had earned for good.
The burden is on you to show unfitness continuing indefinitely into the future. So did you put in anything that showed that this is not a parole eligible sentence?
Well, we have that he is going from 4 to 6 years in this case. The Board of Probation record was put into evidence. And while we agree that it is possible that he could have parole, it was not actually in the record, and parole is not a guarantee.
No, I understand all of that. I'm just trying to get facts straight. You agree that these are parole eligible sentences?
My understanding is I believe that the defendant could possibly be on parole for these cases. I do not necessarily believe that the charges itself would define that he would not be released for parole. However, there was no information that he would actually be. And as I cited in my brief, parole is not a guarantee in this, and it would not have been appropriate for the judge to play a guessing game at the expense of the child in this.
I'm just asking about the facts that he found.
Yes, the only definitives that we know is that he was sentenced in April of 2018. He was arrested in 2017, and that the end of his term of incarceration is 6 years, which would put it in 2023. So those findings were not erroneous by the judge, especially given the definitives that we are actually given for the facts in this case.
May I ask you to jump forward onto a different topic slightly and address the propriety of the judge's failure to, or the judge's determination that she wouldn't order any visitation and leave it to the discretion of the adoptive parents?
Yes, so this is a best interest of the child determination in this case. And we're faced, unfortunately, with the fact that this father has not been involved in this child's life at all. And this isn't even just in terms of incarceration and the fact that he's currently being incarcerated. He actually was aware when the child was born. He did not have any type of involvement with the child. He was released for a month before he was recommitted for incarceration for a violation of probation and had nothing to do with the child at that point. He did not have any type of bond other than during the 2 months. He did not have, he did not have any type of relationship with the child, except for those 2 to 3 months in between his release and his reincarceration for the charges that he's currently being held on right now. After that, the department had written letters to father asking, my time has expired, but could I continue?
You can finish answering the question.
Thank you. Had written letters asking for any person who was willing to bring the child. Father did not respond to those. It was sent in December and they were sent again in January. And again, father did not have any type of affirmative response to this. And it was only when the social worker actually went to the Department of Correction and was able to visit with father that he then asked for some type of visitation with the child. That means that he went, again, an additional September to May without seeing the child. The judge found that there was no significant bond with the father and child, and that's exactly what the record supports. It supports that when given his own opportunities to volunteer someone or to ask for visitation or to be a part of the child's life, he didn't. It was only when the social worker actually brought the child to the father that he did.
Justice Hand, does that answer?
It does. Thank you.
Okay. Thank you very much, Attorney Atta. Your time has expired. We will hear next from counsel for the child, Mr. Dennis.
May it please the court, Your Honor. Can you hear me?
Yep.
Thank you. My name is John Dennis, and I'm representing the child in the case. And just a couple of things. One, the judge made 158 detailed findings of fact in this case, and they address, at least by my count, 5 factors that would show a father's unfitness and that it would continue to a near certitude into the future. We've only touched on some of them so far. One, his gang membership and failure to disaffiliate himself from the Bloods, his criminal record, which renders him unavailable to take care of the child, his actual endangerment of the child during the 2 months that he lived with the child, including leaving a loaded revolver in a box in a room accessible to the child, domestic violence with the mother in the child's presence, which is detailed in the judge's findings, and his untreated mental illness. All of those things go into the pot in supporting the judge's finding that the father's right should be terminated. And as for the best interests of the child in terms of the custodial plan that the judge ordered, placement with the pre-adoptive family, I can tell the court that I have been in communication with my client as recently as yesterday and with the pre-adoptive family, and she's doing extremely well.
When you say you've been in touch with your client, you spoke voice to voice with your client herself?
I have met my client and we've done voice to voice with the pre-adoptive family throughout the case.
And so, but you spoke in the last several days again to your client herself?
The client with the parents, pre-adoptive parents.
But she said you heard her speak.
She's about to turn 5 at the end of this month.
And she remains in the pre-adoptive placement.
She remains in the pre-adoptive placement with the other 3 children, along with the maternal grandfather, who is a support in the family. I can also say that the pre-adoptive family provides, through an open adoption agreement and willingly with mother, visits, extensive visits as well with the maternal grandmother, and also visits with paternal grandmother. And as I understand it, they are supportive. I believe they think
this is all outside the record. I know that it's permitted, but it's what's going on now is outside the record. But I do appreciate, I always ask, even though it's outside the record, whether the lawyer has actually spoken with the child and whether the plan has, disrupted in some way. Because
it is in the record that the pre-adoptive family is open to supervised visitation with the family members, as well as, I think, supervised visitation in their discretion with father. So if that's that's my understanding. And as far as I think the judge's findings supporting the placement with the pre-adoptive family do show that placement is in the best interest of my client. And I would urge the court to affirm the judgment and the findings of the court below. And if there's any other questions.
I see none. Thank you very much to all 3 of you for very helpful arguments. These are always terrible and difficult cases for us, and your assistance is essential to our doing the best we can with them. So thank you very much all for excellent arguments. The case is submitted as well if they wish. We will begin when the clerk's office announces that we are recording. I will call the case before calling upon you to begin. So with that, we will stand by.
The case is now being recorded.
Good morning. Welcome to the Appeals Court. I am Justice Rubin. I am joined today by my colleagues, Justice Singh and Justice Hand. We are hearing argument today by teleconference due to the ongoing pandemic. The rules are the same as they would be in our courtroom, 15 minutes per side with no rebuttal. The next case is number 19-1722, Lagadimas versus Big Y Foods and another. And we will hear first from Attorney Rayner.
Your Honor, I'm not seeing the clock.
You will in a moment.
Oh, there we go. All right. So I'm Andrew Rayner. I'm the litigation director for the Public Health Advocacy Institute, which is a nonprofit organization that for over 30 years has been advocating and litigating against the tobacco industry. In this case, we represent the family of Dawn O'Toole, a woman who died tragically at the age of 54 from lung cancer caused by smoking Newport cigarettes since she was 13 years old. The appeal seeks a reversal of a judgment in favor of R.J. Reynolds Tobacco Company that I submit was premised on 3 erroneous and prejudicial evidentiary rulings. 2 of these evidentiary rulings present questions of first impression for this court. And frankly, they are issues that come up repeatedly in tobacco litigation. And so I respectfully urge the court to rule on them. One of these is the ruling that allowed a defendant in a civil case to argue impeachment evidence as substantive evidence on the primary claim in the case. That's a repeat issue because the tobacco industry playbook is to rely on sound bites. And that's exactly what they did in this case. They took two pieces of impeachment evidence and argued them as substantive evidence in support of the finding that they asked the jury to
All
make.
right, so let's start with this argument. In a federal court, of course, under the federal rules, which we don't have here in the Commonwealth, impeachment evidence that is within a hearsay exception because it is a sworn statement made under oath at a prior, I think it says proceeding, including a hearing, trial, or deposition, is admissible for substantive purposes, may be relied on for substantive purposes. In the Commonwealth, we have not adopted rules of evidence. It's a common law thing. But in criminal cases, there's language in one criminal case at least that simply states that as the rule. Substantive, if it was under oath, substantive evidence can be used. Is there any argument for why, if we're willing to let someone go to jail based on this stuff, why under oath impeachment, hearsay within the exception oughtn't to be used as substantive evidence in a civil case as well?
Your Honor, because it's backdoor evidence. That's
true in a criminal case too.
Well, in Commonwealth versus Day, there was an issue of witness intimidation, which is discussed at length in the opinion as an important policy that caused the court to change what was then an 80-year-old and long-established rule, which, as we point out, is still instructed in the model civil jury instructions.
Okay, but the model civil jury instructions have nothing to do, right? That's not a holding of a court. Someone wrote those, and they might be right or they might be wrong. I'm just trying to figure out why, as a general matter, in the federal rules of evidence allow this. The Commonwealth now allows it, not limited to grand jury testimony. I guess maybe it's dictum, but the court, as at least the SJC at least, has said, and we ought to pay attention to that, even if we think it's wrong or whatever. I'm just trying to figure out why not.
All right. Well, so the main thing I want to say to Your Honor about that is we do not allow parties in civil cases to stand up and decide that right now I'm going to read into the record the transcript of a witness's deposition. We don't allow.
But this was allowed in this case, as I take it, as a prior inconsistent statement. Now, we don't have all of the transcript from those cases. And I note that even in the deposition, and I think we'll get to this, although time runs short, even in the deposition, it seems to me, at least Dr. De Franza said exactly that if the nicotine level was below a certain threshold, he said he didn't know what it was, it wouldn't be addictive. But assuming that this is, and we don't have anything to show otherwise, that there was no such qualification given at the two prior trials, I'm not sure I understand why De Franza isn't allowed to, why having impeached him with that prior inconsistent statement, why that shouldn't come in same as in a criminal case. I mean, I understand you're saying in the criminal case, it can be grand jury testimony, intimidated witnesses. We actually have a separate rule for feigning memory loss and bringing in grand jury testimony and so on. This is just the prior inconsistent statement rule. And I appreciate that for 80 years, we didn't bring it in. I don't know what the federal rule was before 1975 when the rules of evidence were adopted, but they were there. And here we have these decisions of the SJC, admittedly all in criminal cases. The fact that we can distinguish this because it's a civil case is fine and good, but you have to persuade us why we would do that. And I'm having a hard time understanding why it's worse in a civil case than in a criminal case.
Well, and first of all, Your Honor, there's always a much greater record in civil cases. There are legions of depositions. In tobacco litigation, there are witnesses who have been deposed hundreds of times.
But you're supposed to rehabilitate them.
Well, Your Honor, I mean, I guess I'm gonna slip over to the first issue because we weren't allowed to.
Okay,
And
so
if I say nothing else. I'm sorry.
So to me, that's the hard issue here.
All right, well, let me
Unless
focus.
you can tell me that there's a reason to distinguish civil cases from criminal cases with respect to the substantive use of the testimony, then after reading your brief, I thought, oh wait, 80-year-old rule, and then I read their brief, and I should say I teach evidence, so I'm familiar with the federal rule, but I understand that's not applicable here. I just can't figure out why there'd be a different civil than criminal rule. All right, so let's now go to these limitations on testimony and rehabilitation.
So if I say nothing else, I would like to ask the court in reviewing the record to please read Appendix Volume 1, page 126. On that page.
Yes, I've done that. He says a cigarette with some low amount of nicotine would be non-addictive.
He also said something else, Your Honor.
Yes.
He also said that if she had smoked it, she would not have become addicted. We were prohibited from reading that.
Okay.
We were prohibited from reading that. And I would also ask the court, the one other citation, page 4021 of the transcript, where defense counsel in his closing on this issue, on this claim in the case, he specifically talked about our failure of proving the point that we were not permitted to raise. The jury went back, Your Honor, if I just may finish this point, the jury went back with only one court transcript, only one, the only of any witness of trial or deposition, they went back with only the one transcript from the Warshawski case, where Dr. DeFranz is saying, now in writing, there's no safer.
Why was that the only thing they were allowed to bring back with them?
Because the judge ordered it. Judge, that was part of her mistrial order. That was the fourth provision of her order, that transcript was going to go back to the jury. We weren't allowed to put a transcript back there, and there were no other transcripts put out there. So the jury got that one-sided view. And so I respectfully submit.
Sorry, can I interrupt?
Sorry.
So I need to parse this. I find it very complicated to figure out what the real issues are here. So I think that the testimony at trial of Dr. DeFranz, so let's leave Cummings out of it for a minute, or maybe more than a minute. I think that it was consistent with what he testified in his deposition. I do not believe there was new testimony. I am confused by him saying he's changed his mind. Maybe he changed his mind since Warshawski, but it doesn't look to me like he changed his mind since the deposition. But he says he did, which confuses matters, right? Because then that sets up a don't jump us with something new argument. But I don't think that the defendants were being jumped with something new. And I do think counsel, I don't know if you were trial counsel, I think trial counsel said to the judge, one of them did, said, it's not inconsistent, and she rejected that. And I'm willing, for the sake of argument here, to say, okay, that's an error. Okay. So then she says, he can't bring in anything new and Rule 26 and da-da-da. I'm even willing to say nobody was jumped with anything. So even if Rule 26 applied here, there's no need for further disclosure. It's right in the deposition. I don't really understand why there's confusion about that at trial, but trials are fast-moving things and complicated. And I don't know, but that's what seems to happen. Okay, but then you are, maybe you're not allowed to read it in. You do weirdly rehabilitate, quote unquote, Dr. DeFranz in the only way I guess you're allowed to, which is ask him a single yes or no question, you know, did you say blah, 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 or I don't remember how you do it exactly without reading it. And the judge says, can you fix that? Because I don't know why she won't let you read it, but she won't. And so you fix it, or someone does, by saying, you know, without reading it, did you say this? And that comes in, and the answer is yes. And that's the last that's done with it. Okay. Were you limited in asking anything about the prior testimony?
Yes, I asked that we be allowed to read in the same fashion that defendant's counsel read. This was the question. This was your answer. Wasn't it? She wouldn't let us do that.
Okay.
And I mean, that's if your honors look at pages 1879 to 85, that is the sidebar at which she prohibited us. And she also prohibited us from saying the sentence I said a minute ago, that had Mrs. O'Toole smoked this low nicotine cigarette, she wouldn't have become addicted. And that's the critical issue that defense counsel argued.
Now, I look at the closing arguments, and I see that they, having put in no evidence of their own, that there was no such thing as a safe cigarette, they do use the quotes from Cummings and DeFranza at prior trials. That's the evidence they have. And then we get to argument 2. Let's, for the sake of argument, say they can do that. How are you injured? Your closing is after that. And you don't say, don't let them tell you this. As he testified, when asked if a low nicotine cigarette could be created that wouldn't be addictive, he said yes. You don't say that. You, and I don't know if it's you or someone else, whoever's doing the closing says, their own evidence is that at 0.4 milligrams, it's not addictive. Their own evidence is right. So you do make the argument that's not right. It's not right that there's no such thing as a non-addictive cigarette. Their own evidence shows it. That's how you argue it. Now, if you said to me, I couldn't argue the other, I might say, well, okay, now tell me about that. Well, maybe I will. I don't see how you were prohibited from arguing if this was the important thing. If you thought the DeFranza and Cummings things were these home runs they had entered manipulatively and falsely, surely you could have said, he said on the stand when I asked him, did you testify that there was a non-addictive level? He said yes. But you don't even say that. So where's the prejudicial piece of the error? Over to you.
Your Honor, on page 53 of in the addendum, we reprinted Judge Buckley's order. Plaintiff's counsel in closing may not mention any new theories / change opinions of Dr. DeFranza on any subject he allowed to testify in this case. Now, we're walking a line. Your Honor, you can see from the sidebar, you could see how heated this got. We are walking a line, and Your Honor is asking me, how could it be that we didn't address it? We were in fear of being smacked in our closing if we went anywhere near this topic, because she had written in her order, we were not allowed, and we were not allowed to say that smoking the safer cigarette that Mrs. O'Toole would not have gotten addicted. Critical fact, we were not allowed to say that.
All right, I will certainly ask your brother about that.
Thank you.
I wish our arguments were longer. Your time has expired, and I've dominated this whole argument. So, Justice Singh, Justice Hand, do you have questions that I failed to force you not to know? All right, seeing no further questions, I think we understand your argument and the facts going on here quite well, Attorney Rayner. I hope so. We have your brief to the extent we don't. And
can I say one thing on the last issue? Just
okay.
One thing. All right. This issue of motivation is always raised by tobaccosmen. Oh, as we say this, we offer in our brief 3 ways the court can resolve it, but the way it was resolved here cannot stand. That's all.
Okay. Yes, we'll get to. I'll ask your brother about that. So, Attorney Roth.
Thank you, Your Honor. May it please the court. Yaakov Roth for the defendant appellee, R.J. Reynolds Tobacco. Your Honors, this is an appeal from a defense verdict after a lengthy trial where there's no legal challenge to the jury instructions, and plaintiff instead is asking this court to order a do-over based on 3 discrete and fairly narrow evidentiary rulings. We would submit that the trial judge did not abuse her discretion on any of these issues, that 2 of the issues were not adequately preserved for appeal, and that right or wrong, none of these rulings was prejudicial enough to warrant relief regardless. And I'd like to start where the argument ended on the limitation on Dr. DeFranza's redirect testimony, and specifically address Justice Rubin's inquiries about the deposition and whether it really was consistent or inconsistent. And to me, there's sort of a strange tension in the plaintiff's argument here, because insofar as the deposition testimony was consistent, and I understand there's an excerpt of it that's fairly close to, I think, what Dr. DeFranza was trying to say at trial. Insofar as it was consistent, there was nothing that prevented testimony about that. Nothing in the judge's order.
The judge ruled it was inconsistent. The judge said specifically, twice counsel for the plaintiff said, but it's consistent. And she's like, no, this is new. Now I believe that's, I don't know what that is, an erroneous factual finding or something like, no, I guess it must be a fact finding. But that seems wrong to me, but they did say, no, it's consistent. And then I am now looking at this order, and point 5 is plaintiff's counsel in closing argument may not mention any new theories, changed opinions of Dr. DeFranza on any subjects he's allowed to testify to in this case. So I don't understand why that's, I understand maybe we can talk about prejudice, non-prejudice, but I don't understand how that can be right if we're in at least largely in agreement that it wasn't a changed opinion from the time of the deposition.
Your Honor, I think what's going on here is there's different parts of the deposition. And initially, and it's all on the same page of the record, which is 126, what plaintiff's counsel referred to. Initially, there's a line of questions that asks, does it depend on the level of nicotine? Does it depend on the brand? And he gives unqualified answers to those questions. Then there's a subsequent question where he sort of walks it back a little bit and says, well, there might be something that I'm not really sure about that doesn't contain nicotine, or that he says it has super low levels, which he defines as essentially none, that might not be addictive. So there's 2 parts.
Because he doesn't know what the level is, right?
I think that's right. He doesn't know.
Okay.
He says maybe it's, he says for my purposes, essentially none. But I think the issue is, Your Honor, let's say it was consistent and the judge was wrong in saying that it was inconsistent. I think the question is, so what flowed from that error? If it was an error, what flowed from it? And I would submit nothing flowed from it. In redirect, plaintiff's counsel did take the Dr. DeFranza to that excerpt and walked him through it to maybe, I mean, I'm not saying he did a great job of it, but certainly that was, if you go to the...
Well, he tried to do it. I mean, again, look, this is always hard for us. I wasn't in the courtroom. The judge has gone essentially ballistic about this in a way that seems, again, I don't know the judge. I don't know any of you. I don't know anything. You know what I mean? I've never been in that courtroom. I don't know. But the judge makes it seem like it's trial by ambush. It's unfair and it's terrible. Partly because, I don't know if it was you or some other lawyer for your side, says like, Your Honor, it's trial by ambush. It's terribly unfair. And okay. And the judge really goes off on this tangent. And I can't say that I wasn't there, but I could read the words. All right. So she takes the time to put the fear of God into the plaintiff about this. There might be a safe cigarette with a low enough nicotine level, safe in the sense of less addictive, not in the sense of less carcinogenic. And she goes to all the trouble of writing this very unusual order. This will be read to the witness, who then I won't let testify until he says under oath that he's read and understood it, which is not normal or usual or typical, right? I don't know if I've ever seen something like that before. So everyone gets this is a big, big deal. And then they get to cross-examination, and I don't know how to tell. Gee, they're not very good at redirect. I mean, gee, they're not very good at rehabilitating this guy. Versus, well, they try to read the thing in, which might have been stronger, and they can't. And the person is so scared that he's saying, "I'll fix it, Judge. Just let me." And they do get in the record this one yes. They don't mention it in closing, but there's an order telling them not to, it seems to me.
Your Honor, I think the order is telling them that they're not allowed at closing to talk about new or changed testimony. And if you look carefully,
the judge has ruled. You asked what flowed from her finding that this was new or changed.
I don't think, no, but Your Honor, I don't think so, because I think if you look at the sidebar discussion carefully, they give her the deposition and they say it's consistent. And she says, I see that it's sort of in this vein, that vein over here. But she says, but she's asking the exact same questions and he's not giving the same answers. So you can't say he didn't give those answers. If you want to take him on redirect to rehabilitate and say it's consistent, go ahead, and he does. Your Honor, what I'd like to do though is I'd like to point the court to places both before the order, in addition to the excerpt from redirect. Okay, so we've talked about the redirect, it's on page 1900. And by the way, that redirect, I would just point out, is exactly what plaintiff's counsel said before the judge ruled, okay, that he wanted to do on redirect. So in other words, you look at page 1803 of the transcript where they're having this discussion, and plaintiff's counsel says, the only redirect I had in mind for this issue is to simply read a portion of the deposition. That's all he says he wants to do to show consistency, not to say that there's some new theory that I want to defend, but to say, no, this has always been his view, okay? And she doesn't say you can't do that. And then we've talked about page 1900 is where that excerpt happens. I also, though, would like to point out.
Wait a minute. There's also a point at which she says she overhears counsel talking, and you may not do that. You may not, I think it was read the deposition.
He wanted to read it like Q&A.
What's wrong with that?
You know, Your Honor, I'm not sure why she wanted it done a certain way, but the substance, there's no question the substance came in on page 1900.
Okay, but I'm now focused. I mean, it's hard for me to tell how much better redirect would have been, but I'm really focused on the closings. I'm really focused on the closings where all the evidence you have is these two statements, Cummings and DeFranza, these unqualified statements. And I didn't litigate this below. It seems like you guys litigated it extremely well, and maybe the other side didn't litigate it as well. And so maybe they lose. You know what I mean? Like, you guys are both sides are very, very good lawyers. This isn't, we see cases with very bad lawyers, and this is not one of them. You guys are very, very good lawyers. And that's for all the reasons that we know. So what's at stake and so on. All right, so you're very, very good lawyers. But your evidence is these two statements, and they do say, look, Laura Lard or whoever it was at the time said 0.4%, and that's what they stayed below. They certainly argue in closing that you could make a non-addictive cigarette. But they don't say, and it may be true that 2 years ago in a trial, DeFranza said X, but in this case, he's been clear and consistent that that's not the whole story, and that there can be one. He's not expert in where the number is. It's non-addictive. They don't say that, and they're not allowed to. I think the way I read that.
Your Honor, I don't think there's a basis to say that they were not allowed to highlight in closing a point that they were allowed to bring out on redirect. In other words, to point to the part of the deposition that was closer to what he was saying at trial, as opposed to the parts where he gave unqualified answers, yes, 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 doesn't matter, doesn't matter, doesn't matter. Then he says, well, maybe there's something, and she lets it come in. So I don't know why they couldn't have mentioned that. I also, though, think...
Yeah, I mean, I have to say, look, I don't understand the judges. The judge has drawn these lines that seem confusing at best to me. She clearly doesn't want what she views as changed testimony. But she seems to say it's changed, although she does let in that rehabilitative, not quote, which might have been stronger, but she lets in that one yes.
Your
I
Honor,
find it very difficult. This is very confusing to me.
okay,
And I
Your Honor,
can't tell how much difference it made either.
Yeah.
I mean, right? I mean, that's the other piece of this is the error has to be prejudicial.
Your Honor, the error has to be prejudicial, and it's plaintiff's burden to demonstrate that the error is prejudicial.
Yeah, I
I could
agree.
just make a couple of points on that specifically. Okay, one is, I think bearing on that question is the fact that we don't have an offer of proof here. Okay, we don't have anywhere the plaintiff's counsel saying, I understand your ruling. If absent this ruling, here is what I would like to do. And we usually require that. And the reason we require that is specifically so that this court can engage in meaningful appellate review of the question of prejudice. And it's very hard to do that. And I think some of what we're struggling here with about, well, this, they said this there, they didn't say that, would have been fixed if we had a proper offer of proof that said, I'd like to ask these questions and here's what he would say. It's in the record that that didn't come in. We don't have that here. I think that cuts against the plaintiff on showing prejudice. If indeed, I think it arguably is a forfeiture issue under this court's cases, but it certainly bears on prejudice. I also think in addition to the redirect, there was testimony on cross before the judge's order where he said these things several times. And remember, the judge's order comes after cross, before redirect. So he's already had.
Well, it comes sort of during cross, doesn't it?
It comes during cross, but after this topic is discussed. In other words, when they come back the next day, continue cross, they're on to a different topic. They don't return to this issue. We do have testimony from Dr. DeFranza, and I'd point the court to pages 1770, 1771, 1772, 1773, where he says, well, if you're talking about the normal amounts that are in normal regular cigarettes and lights, they would all be addictive. If you're talking about some cigarette I'm not familiar with that has ultra low levels of nicotine, they might not be addictive. I'm not an expert on what's on the market. And he says he gave this prior testimony, but he didn't know that he didn't know certain things. And now, if you're comparing light cigarettes like Marlboro Lights and Newport Lights, yeah, they all have about the same amount. They're all addictive, but there are some experimental cigarettes that have zero nicotine or trace amounts of nicotine. Those probably wouldn't be addictive, the trace ones. All of that comes in, and he comes back to it several times in the course of the testimony before the judge's order. And I think
one point where someone said something about 0.05 milligrams.
I don't think that's with him. I think that's with Dr. Cummings, Your Honor. The discussion was about particular levels. Dr. DeFranza never committed to any particular level. He said at his deposition, essentially none. And then he sort of at cross, he said, well, I don't know, there might be some level out there. I'm really not sure. I'm not an expert on that. But again, all of that came in. Also 1790, he testifies to that to explain his prior testimony, 1792 of the transcript. So it's all over, it's got to be 5 or 6 or 7 times in the course of his cross-examination before the judge ever rules. He conveys this point.
Okay, we're running out of time. I want to ask you one other thing. Why are you allowed to say that punitives go to the plaintiff? What's the relevance of that?
I think the point is the jury has to understand where punitives go and where they don't go.
Why?
In other words, the jury, I think it's just a fact. The punitive damages don't go to.
I didn't say it wasn't a fact. I'm trying to find out why it's irrelevant.
Well, I think perhaps, Your Honor, the easiest answer to that in this case is the jury never reached the question of damages, let alone punitive damages.
That's not the point. Your point presumably was trying to show that it was greed rather than altruism that leads people to seek punitive damages, right?
There was no suggestion along those lines, Your Honor.
Well, what's the point of saying where it goes?
Because I think if the jury believes that punitive damages are going to go to charity, then there's an inclination to say, oh, let's give a lot of money in punitive damages because it's going to be great for society. And I think the jury, it's appropriate to tell the jury punitive damages are to punish, but they don't go to social welfare.
I don't understand. You say it's appropriate. Why? If the legislature has determined, so in Massachusetts, we don't have punitive damages, as you probably know. They have to be specifically allowed by the legislature. There's no common law punitive damages. So if the legislature decides that the best way to punish and deter really bad conduct is through punitive damages, and not that 8% should go to the plaintiff and 92% to a fund or whatever, just punitive damages to the plaintiff. If they've determined that's what will punish and deter, why do you get to say, no, they won't? Because they only go to the they don't really serve a public good because they only go to the plaintiff. I don't understand the relevance of that, why the jury needs to or should know anything about that.
Your Honor, I don't think the suggestion was that this isn't going to, there isn't a purpose to punitive damages or that it's not good. I think that this was a one line in closing argument.
That's not my question.
Was, you know,
I want to know, I'm not saying it was necessarily harmful error,
right.
But I don't understand why I understand why you might want to say it, but I don't understand why it's lawful to say it.
Well, I think, Your Honor, if it's correctly conveying the law, then there's nothing wrong with advising the jury of that.
No, that's not true. We, in a death penalty case, we don't say to the jurors voting on the death penalty, oh, and by the way, the judge will have the power to knock this down. He can't raise it up, but he can knock it down if that's the state law. You would never tell the jurors that so that they would not feel their sense of responsibility, right? You can't. There's lots of things you can't tell the jury. You have the power of jury nullification. You can't tell them that, right?
All right. Well, I take your point, Your Honor. I think I would rest in this case on the fact that, number one, I don't believe that the appeal was on the ground of the improper question. The appeal was on the ground of whether there should have been testimony allowed about the charitable trust, which I think is inappropriate and not an abuse of discretion. Number two, I certainly don't see how there could be any possible prejudice in a case where the jury found no liability and never reached the question of damages. But I understand your position on the whether it's relevant.
Well, it's not my position, it's a question.
For the question, I understand the question, but I don't think in this case it's something that really presents any legitimate challenge to the verdict, because the verdict was on liability grounds.
All right, your time has expired. Again, I've dominated the argument, so I will ask if anyone has anything else. I see no customer time to ask a question. I wish our argument time for some cases was longer. I rarely say that. It's often the opposite. But excellent job, both of you. You know, this is a fully and thoroughly litigated case. So thank you very, very much for your excellent argument. It's very helpful to us.
Okay, thank you, Your Honor.
Case is now being recorded.
Good afternoon. Welcome to the Appeals Court. I'm Justice Rubin. I'm joined today by Justices Singh and Hand. We are hearing argument by teleconference due to the ongoing pandemic. The rules are the same as for argument in person in our courtroom, which is 15 minutes per side and no rebuttal. The next case is number 19-1658, DEBEM versus 2168 Central Street Realty Trust. And we will hear first from counsel for Ms. DEBEM, Mr. Mateus.
Thank you, Your Honor. May it please the court, John Mateus for VALDETE, DEBEM, and all other plaintiffs. Your Honors, the most important issue the court has before it in this case is this: have the plaintiffs presented enough evidence to show a genuine issue of material fact as to their claims of negligence? The answer is yes. There is a genuine issue of material fact, both to duty of care and causation. The grant of summary judgment, therefore, should be reversed. By way of brief background, at a New Year's Eve party spilling over from December 31st, 2017 to January 1st, 2018, Mr. Antonio DEBEM fell down a set of stairs in a home owned and maintained by the defendants, who are professional landlords and have owned the home for a number of years. Mr. DEBEM was a guest of not directly of these defendants, but somebody who was renting the property. Mr. DEBEM died of the injuries caused by this fall during the course of this court case. So his wife, Ms. DEBEM, she filed this suit on behalf of herself, her daughter, and her capacity originally as guardian, and then as executor of the estate, alleging negligence. The defendants moved for summary judgment, and the trial court granted it in a written opinion. This was an error because there was genuine issue of material fact. The proof of such issues of material fact, excuse me, Your Honor, I apologize, were both the submitted photographs and the expert report from one Peter DePisa, Both of these are in volume 1 of my appendix that I've filed. Mr. DePisa was a former building code official and a general contractor for 50 years. The photographs depict the stairs down which Mr. DeBem fell, and according to Mr. DePisa, these stairs had multiple Massachusetts building code violations. The photographs show that, and this court is free to look at them because it's reviewing de novo. These are the same photographs that the court below looked at. The photographs of the stairs show them to be highly steep and without guardrails, or at least proper guardrails. And the expert report from Mr. DePisa details that the stairs had a trip hazard, failed to provide additional grit to the paint to make it less slippery, which was in violation of the code, according to Mr. DePisa. The handrail was not the proper height, also in violation of the code. There was not a guardrail where needed, in violation of the code, and the stairs were excessively tilted forward, in violation of the code. And Mr. DePisa also stated that the basement was built without proper permits and inspections. The expert then stated that as a result of these violations, this accident was preventable had the code not been violated.
What basis did your expert have to say that?
The expert stated that, in his 51 years experience as a carpenter, superintendent, general contractor, and code official, that had these proper railings and non-trip measures had been followed according to the letter of the code, Mr. DeBem would not have tripped, would not have fallen down these stairs, and would have been able to be prevented from having the serious injuries that occurred as a result of the guardrails and the handrail being up, preventing him from completely falling and dying as a result.
What factual basis is there in the record to make that determination?
Ultimately, Your Honor, it is only his expert report and his evaluation of the stairs as a general contractor.
But as far as the mechanism of the fall goes, what's the evidence of the mechanism of the fall?
The expert believed that the mechanism of the fall was caused solely because these routine safety measures were not in place.
No one saw the fall, correct?
Correct, Your Honor.
And that's part of the agreed statement.
Yes, Your Honor.
And Mr. DeBem was unfortunately unable to explain from his own perspective what caused the fall, correct?
Yes.
Is that not then speculation on your expert's part about what caused the fall?
I do believe that his experience as an expert makes this not speculation, Your Honor. It makes his expert opinion as to the causation of the fall. Granted, he's not a medical expert, so he cannot determine the exact injuries that Mr. DeBem were caused by the fall. However, he can state that had these preventive measures been in there, the fall in his experience and his expertise would not have been this severe.
Doesn't your expert's opinion amount to an opinion that if stairs are up to code, people don't fall?
I believe his expert opinion is that if these particular stairs had been up to code, then this particular person would not have not fallen is probably too far to go, would not have sustained these types of injuries and not have fallen to the severity that he did.
Was there any explanation as you talk about this particular person? In the expert's report, was there anything taken into account about this particular person as opposed to any person?
No, Your Honor. He merely recites the facts that I have just stated, that Mr. DeBem was at the party and he sustained a traumatic brain injury and was assisting other partygoers grilling food.
The question is whether his report and his professional opinion to a professional degree of certainty would be sufficient to support a finding by a preponderance of the evidence that it is these steps, forward-leaning, uneven, no guardrail, no anti-slip, that caused this accident.
Most respectfully, Your Honor, I don't believe at this stage we have to prove by a preponderance of the evidence.
No, sufficient to support a finding.
Sufficient. It definitely could support an ultimate finding. And
obviously a jury could reject it. They could find something else.
And there could be more evidence presented that it would support it. At this stage, Your Honor, which is obviously in my brief, one of the issues that we raised, we believe that the trial court judge had us had the plaintiffs try to reach the preponderance of the evidence standard at the summary judgment stage, which we thought was erroneous at that time. And moving forward, Mullins v. Pine Manor and Lieberman v. Powell, which we cite in our brief, state that an expert's opinion is sufficient proof of causation. In Lieberman, summary judgment was actually reversed based on expert opinion. And that was the cat case where a cat attacked somebody in a shelter, and the expert opined that the way the shelter was designed had caused the cats to basically become overstressed, and that overstress caused the attack. This was enough to defeat summary judgment at that stage. Again, not enough to prove beyond by preponderance of the evidence, but that's not the standard summary judgment. These two pieces of evidence, the photographs and the expert's report, were enough to show a breach of the duty of care and causation. It's black letter law that both violation of regulations such as a building code is proof of negligence, and that an expert's report is enough to show causation, and that's Mullins and Lieberman. In this situation, the expert's report stated, and it lists a number of code violations. This isn't just one on the stairs that caused them to be dangerous. That was enough to show a breach of duty of care and causation at this point. Now, not to get off my own argument, but to answer the arguments in my opponent's brief, the opponent's entire brief and argument is made up of trial defenses, not summary judgment arguments. The opposing counsel has raised the issue of intoxication. Intoxication goes to contributory negligence. That's a defense. It was not even presented in their original argument, and specifically at oral argument. Originally, they specifically said, we're not going to bring up the issue of intoxication here. This is a trial defense, and it should not be something. The only question is whether the plaintiffs have raised enough to show a genuine issue of material fact. Secondly, they attack on this expert as stating that his opinion would not have been admitted as an expert. First, the trial court judge specifically stated, or admitted, I should say, that she had not ruled on whether the expert's testimony would be admitted as an expert as such. She said it was questionable, but she did not make a ruling. At the summary judgment stage, therefore, the judge and this appellate court should assume that the expert's report should come in as an expert's report. Now,
is that a legal question?
That is a conclusion. That is a conclusion of law because she has not made a ruling as to the expert's admissibility. If they want to challenge the expert,
what would she? I mean, is that something we review de novo, or is that something where there might have to be a hearing about it or additional evidence taken or something? Like, does it have to stand alone? I guess I just don't. I don't know how this works. Now I can't tell if everyone's frozen or just thinking.
I think counsel might be frozen. It looked like he was pondering for a moment.
I think he's thinking really, really hard.
There you go.
Wait, I'm sorry, you were frozen for a moment there, Attorney Matus. And you're frozen again. Oh, that's too bad. I thought he was thinking really, really hard.
It looked that way.
Counsel, okay.
There we go. I am here. You're back. Okay, I'm sorry. Okay. The expert. This court should assume, for the purposes of summary judgment, that the expert's report would come in as an expert's report. If the opposing side had wished to not have that be the case, they should have challenged the expert's report before the summary judgment hearing, had a voir dire, had the court make a ruling. They still have that opportunity before trial. That's a trial defense to try to kick out the expert as an expert. But for the purposes of summary judgment, this court and the trial judge should have assumed that the expert report would have come in fully as an expert's report.
And we've lost your brother, but I guess there he is. Oh, the intoxication. Was evidence of intoxication in the summary judgment record?
Not in the original one. I know opposing counsel has put in a one-page, via motion that we did not object to, put in a one-page.
Put in here or below?
They put it. Opposing counsel put it in here. And
so we have a pending motion about that, presumably.
I believe it was accepted. I
It may
believe this court-
expand, well, unless this panel votes on it,
Oh, I understand.
nobody's
Well,
expanding the record,
Right.
I hope. I don't know if the
Uh,
clerk's office purport, I will ask your brother where that is. But in the trial court,
No,
Did
there
the
was
trial-
not. There was nothing presented about intoxication. In fact, I state in my brief, and I point to, it's on the transcript on page 6 of the hearing, where they specifically state that they're not here to argue about intoxication. And there are, and at certain points in the transcript, opposing counsel does state, well, he was intoxicated, and so we're going to raise that issue at trial, and it's really, it's really a question of whether intoxication, wasn't, overcomes our fault.
that's
And
comparative negligence question?
yes, and that would be yes, I believe so, Your Honor. That would be, and that would be defense. Again, that's a trial defense. It's not a summary judgment argument. Whether he was intoxicated or not, the question is, did we allege enough standing alone that if our case were totally believed and the other side's case were totally believed, this would be enough to raise a question? We did. The code violation is enough under the law, and the expert's report showing that code violation is enough under the law to overcome that. However, intoxication was not raised. This evidence was not presented. We would object to it coming in at this time, but I understand this court can review de novo, so it can expand that. But we think it's irrelevant at this point because intoxication against defense.
We can review it de novo. We don't get to allow in new evidence. What do we know about evidence?
Your brother indicates that it was part of the record in this motion.
I did not see it in the record. Granted, Your Honor, I don't think it's a point to really get hung up on it this from our point of view, because as we stated, intoxication is a defense. So no matter how much intoxication evidence is coming in, the question is, if that were totally not believed and our side were totally believed, would this be enough to make people think that the defendants were at fault, or at least raise the genuine issue? Now, the issue is they're going to raise intoxication. It's New Year's Eve. There is, there is a tradition of drinking on New Year's Eve. That would be expected in most situations. However, that's unproven. Whatever this document proves here, we would, it has to be subject to cross-examination, has to be subject to motion to eliminate challenges. They are raising their trial defense at a summary judgment stage, which is improper. And I would also argue that there's a policy reason for this court causing a reversal here. In her decision on this matter, the trial judge stated that the plaintiff is required to introduce evidence from which a reasonable person may conclude that it is more probably true than not true. The event which caused the decedent's demise was caused by the defendant's conduct. That is the preponderance of evidence standard that we have to carry at trial, not at summary judgment. And if this court does not, if this court upholds the trial court's ruling, then essentially every single time.
Wait, but if there isn't evidence sufficient to support such a finding, then you lose as a matter of law. Right? If there isn't evidence, there has to be evidence sufficient to support a finding by a jury, right? We don't have to find that you've proven it, but if there isn't sufficient evidence to support a finding, isn't the other side entitled to judgment as a matter of law?
Sufficient at trial, Your Honor. Here we only need raise the genuine issue of material fact.
But what makes it a genuine issue? Isn't it only a genuine issue if there's sufficient evidence to support a finding on that fact?
And under Massachusetts law, a code violation on the stairs is enough. And we have several code violations that are alleged.
And what's your best case for that being enough?
The code violations are, and if
not to what they are, I know what they are. I'm asking, what's your best case for evidence of a code violation is enough to raise a genuine issue about causation?
Well, there are three that I would cite, but my best case would probably be Perry v. Medeiros. It's in my brief. Also Fox v. Little People School. And the most recent one I cited was Campbell versus Cape and Islands. Okay. In all three of these cases, a building code violation was found to be proof of negligence.
Okay. Your time has expired.
Thank you, Your Honor.
Thank you very much. This is a surprisingly interesting case, I think, to all of us. And we will hear now from you, Attorney Carroll.
Thank you, Your Honor. I appreciate it and may it please the court. I am here to argue on behalf of the appellees in this case. I would start by pointing out from our perspective, ultimately, what occurred at the summary judgment stage. We moved for summary judgment, and the thrust of the argument was that the plaintiff would be unable and is unable, based on this record, to present sufficient proof at trial to meet an essential element of the plaintiff's claim. In the brief that was submitted on behalf of the appellant, there is both a duty argument and a causation argument. I want to just start by saying we're not here to argue that the plaintiff could not prove that there was a duty, there's a general duty as a party who demises premises under a lease to a tenant, or that his expert's report would be adequate to get the issue of duty and breach of duty to a jury. We're here to argue that there is no that the undisputed material evidence in this record is inadequate as of this moment for the plaintiff to prove his case on causation at trial, and that's the standard. And I'll just point out, and just to frame the rest of my argument, that there is the suggestion in the appellant's brief that somehow there was a burden shifting that was to the prejudice of the moving party here, or the plaintiff, the opposing party at Superior Court level. That's not the case. We made a presentation in our briefing and in our oral argument that the plaintiff could not meet their burden on the issue of causation, and now it's incumbent upon the plaintiff to demonstrate that in fact that's not correct, and to point out in the record why it is in fact the case that the plaintiff has enough evidence that is admissible at the time of trial to meet that burden. In response to that argument, the plaintiff has made two opposing arguments in the appellant brief today, before the court today, and it's essentially two things. One is, my expert's enough to get me there. My expert's opinion is enough to satisfy that burden at trial, and we can say that today. And then the second is a res ipsa argument. Just briefly on res ipsa, I think the court should spend no time whatsoever on that issue because it's very, very clear, not a standard of law that even applies in this case. It is not it's not an argument that is availing whatsoever based on the black letter law. Just 3 points on res ipsa so we can put it away. One is that the event has to be an event that ordinarily would not have occurred in the absence of the defendant's negligence. There's a control over the instrumentality problem because we divested ourselves of control over the premises to the tenants. We did not have control. And of course, there can be no other cause. It has to be that, for example, comparative negligence. And just so it's clear, and I'll get to it, the issue of intoxication was never advanced to support some argument of comparative negligence. And so I just want to stop for a second and tie up res ipsa. It doesn't apply. And so essentially the plaintiff has placed all of his eggs in the expert's basket. In other words, in his brief, and again today, the reason that counsel would argue on behalf of his client that there is enough evidence to get to the jury on causation is because his expert has some type of an opinion that would get him there. And we obviously contest that viewpoint very strenuously, and I'd like to talk about why we do. I'd start with the general proposition that in Massachusetts, it is well settled that you can't leave the issue of causation or any element of the plaintiff's case in a negligence case to speculation or conjecture. In other words, the plaintiff has to show that there's evidence that would allow, not necessarily prove in prospectively, but that we can say that there's sufficient evidence from which a reasonable jury could conclude that one explanation or one account of what occurred is more likely than other equally plausible causes, okay? And that's the reason intoxication was interjected into the record. What I would argue that if you review the materials, Your Honor, at the Your Honor is at the lower court level, you'll see that it was presented to the court in exactly the manner in which I'm offering it today. I heard counsel say earlier in this.
It's not in the summary judgment record. It was offered as an exhibit to your reply below.
It was offered, if my memory serves, and I will defer to the record, Your Honor. I will do my best to remember it accurately, but I'll defer to the record. As my memory serves, there was subsequent briefings at the Superior Court level during which the intoxication was raised. It was absolutely raised, as both reflected in the appellant brief here before Your Honors today, in more than one way, and it was discussed at length. And I think that, to be honest with you, Your Honor, and also one more point on that, we did move to supplement the record with that evidence, and as counsel just mentioned, without any objection from counsel. So
that motion is before us, right?
I suppose it would be. I'd have to look at the docket in terms of the state of that.
I don't know how you can expand a record on appeal. I've never heard of that. But let me ask you this. Let's say it's in the record. Let me ask you a hypothetical.
Yes.
If a person who was not intoxicated fell on these stairs and you got the same report, that would be sufficient to defeat summary judgment?
Absolutely not.
Why are you telling me about the intoxication?
As an example.
I'm not interested in an example. I'm interested in what's before us. I'm going to assume that a jury would discredit your evidence of intoxication, because that's what I'm supposed to do, right? I'm supposed to look in the light most favorable to the plaintiff, right? So I discredit the evidence of intoxication. What is this? It's from a phony hospital. It's a forgery. It's whatever. I don't credit it. Now we've got a non-drunk person who falls on these stairs and they die. Why is the expert's report not sufficient?
Well, there's multiple reasons, Your Honor. Number one, the law in Massachusetts is that the mere happening of an accident is not evidence of negligence, and that's the starting point. Number two,
I agree with that, but there is evidence of negligence in the code violations and so on. So now we have code violations and an expert saying this fall on the stairs was preventable, in my opinion.
okay, but there's a million different ways and reasons. The reason I raised that body of law is because there's the number of potential reasons why this gentleman fell are innumerable. There's a thing called syncope. The reason I mentioned that is because just because
I agree with you. He could have had a heart attack on the third step. So I have no idea.
It's a completely unwitnessed.
But it only is the preponderance of the evidence standard.
But he has to be able to demonstrate that those things that he has cited caused his fall. Nobody saw it. We don't know whether he fell from the first step.
Unless there's an eyewitness, when a person dies from a fall, you can never prove causation.
Well, I wouldn't say that, Your Honor. I wouldn't say that at all. I would say that what you need some admissible evidence to support
an expert saying, wow, these steps are really bad. In my opinion, he fell because of it.
That would be speculation, because you weren't there and you didn't see it, Your Honor. You don't know whether he fell from the first step or the top step. We don't know whether he was
so you're agreeing with me that if someone falls and no one sees it, you can never have adequate evidence of causation.
If somebody falls and they're not able to explain why they fell,
because they're dead,
as is the case here, and if somebody falls and nobody sees it, then you cannot prove that the reason you fell. And certainly
it's February 4th and I walk out of a Dunkin' Donuts and there's a metal ramp going down to where I've parked my car and there's ice on it. I fall, no one sees it, and I'm found with my head, I had hit the metal when I landed, and I'm dead. No one can sue for negligence for failure to take the ice off of that step. Is that right?
Well, that's a little different, Your Honor, and I'll tell you why. I'm going to tell you why. A couple things, and I think it's, if you just allow me to make this point.
You've got your time. Go ahead.
Yeah. So what I heard counsel say is he started to talk about the severity of the fall and whether it would have been as bad or not as bad had there not been these code violations. That's what I heard counsel say today. I'd like to read to the court the beginning, middle, and end. Every single word that is contained in this report. And by the way, as an aside, expert reports are not admissible. The gentleman would have to get on the stand, but put that aside, assuming that this is what he would say at trial.
Well, nothing in a summary judgment has to lead to discoverable, right? I mean, affidavits don't come in either, so.
It says the accident that happened to Mr. Antonio DeBem was entirely preventable if good construction practices in the Massachusetts State Building Code were followed as outlined in this report. That's all it says. It doesn't say anything about an analysis as to how and why he fell, why it would be less severe had these things not been there. In your example, Your Honor, we have experts in our world, in the world of civil litigation, of which I've been a part of for a very long time, where you can, and very good lawyers do it all the time, you can put the pieces together in the situation you just described, Your Honor, to talk about here is how the plaintiff fell in relationship to the defect, and this is why we can say that his feet went forward and he fell backwards and hit his head. This is consistent with a slip on ice. And we can say based on—
And with a heart attack.
Maybe. Maybe.
Okay, so now it's consistent with two possibilities, and no one saw it.
But here's the—
And no autopsy was done. We don't know if he had a heart attack.
We don't know whether he had a heart attack, and we don't know whether he had a heart attack in this case. By the way,
so you think it doesn't go to the jury in my case? You think that because I could have had a heart attack in that fall outside Dunkin' Donuts, it can't go, the jury doesn't get to decide?
I would say that you could get to a jury in that case if nobody saw it, but that certain things were observed after the fact, and that those observations were then given to an expert who was a biomechanical expert.
But it has to be more than this was icy and he fell.
It has to be much more than that. And of course, here in this record, what we have is a code expert, a building code expert. All this gentleman is qualified to do is to say these code provisions—
I don't know what he's qualified. I don't know what he's qualified for.
Well, how is it that he's making the nexus here?
Well, I don't know.
How is it that he's making the connection between—
cross-examine him about that. I don't know.
He cannot— the factual record is the factual record. Just because he's an expert—
It doesn't have anything about drunkenness in it.
Yeah, well, the factual— well, all the drunkenness does is demonstrate very clearly, bright line.
Of course, there's possibility. Maybe in this case, but we have to—
Well, it would require speculation. It would require speculation.
Do you do any criminal work?
No, I don't, Your Honor.
Okay. So I'll give you an example of a case, an easy case. I don't know if it's easy. A case. A passenger in a car. The driver is in the car too. There's someone driving. When the police search the car, they find a package of drugs between the driver's seat and the console. Obviously, no one says whose drugs they are, right? No one says anything. But we let a jury decide whether the passenger, if she owns the car, that's enough. And now they can decide whether she was the one who possessed them or the driver. If that's not speculation, how can, in the case of a report by an expert that says this is what caused it, how can that be mere speculation?
Because this is not the criminal law, and I would read—
Well, but that's beyond a reasonable doubt. That should be harder.
This is the Alberg, this is the Alholm decision, Your Honor, and this is exactly on point with our case. This is black letter Massachusetts law. And what it says is, there's an affirmative burden on the plaintiff that the issue of whether there's causation here by a preponderance of the evidence cannot be left to surmise, conjecture, or imagination. There must be something amounting to proof, either by direct evidence or rational inference of probabilities, not possibilities, from established facts. Just because the gentleman they're calling an expert is an expert does not relieve the plaintiff from the burden of demonstrating through facts that a jury who ultimately made a decision in this case was basing that decision on rational inferences from facts. There are no facts other than the fact that he fell, And other than the fact that they found some building code violations, they don't know where he fell from, why he fell from, and that evidence will never be in this case. So I think it's a very clear case where they just have no potential whatsoever from placing this before a jury and allowing a jury to make a decision that won't be based on possibilities as opposed to the required probabilities.
All right, I think we understand your argument. It's obviously a close case. It's a very interesting case too, at least to me. But I used to be a law professor, so there we are.